Bail tomorrow, your lordship, substitute matter. Only CD may be called for in this.
Possible. Today also again 55, 55.
No, only most of matter for CD may call. I'll say already focus with it.
Yes, references.
I have filed on 17 years, but I thought that it district was some minor defect. It was corrected. Only regular bail, your lordship. Behind the bar for 3-9. And focus bail already released by your lordship, granted bail. Only CD may be called for in this matter. I will not press for bail at this stage. Tomorrow, your lordship. After vacation, long bail. Tomorrow.
Okay. May I please, your lordship? My lord, item number 21, my lord, criminal petition, my lord. My lord, that matter may be taken tomorrow, my lord. Some matter, my lord.
21
tomorrow, my lord.
after vacation, list after vacation.
Then, my lord, then at 2 today, my lord.
2 I cannot say at this stage because maybe it is a motion matter. We'll try at 2. At 2.
At 2.
Okay.
May I please also? I'd like to mention for item number 34 and 35, lordship. Even the matter may be passed out for the day, lordship. Due to some
34 and 35.
Yes, ma'am. Only after
34 is connected with 35.
Yes, ma'am. Same ma'am.
What you say? What you?
Well,
No. What is your prayer?
adjourn for the day, lordship. Only after the vacation. Any date may be.
Date? Yes.
34 and 35.
CD is not received, okay? CD may be called.
CD may be called.
Uh,
CD. I don't know. Scan copy of LCR. Yes.
Yes, yeah.
No.
Criminal
34 year on 34 and 35. 34 we have received. In
Yes,
fact,
yes, same as.
Yes,
same
ma'am.
as.
34 and 35.
so it's received only.
Scan copy received. I'm sorry.
Scan copy has received.
Yes.
After vacation, if you want any date, if you want any date, then it will be obviously after Bihu vacation, not after prior Bihu. There's no date, in fact. So it will be listed
Vacation
immediately
is
after
long
vacation.
date.
We'll do
Similar
immediately after
first week
vacation.
of January, any date may be.
Huh?
First week of January, second week of January, maybe.
Second
7,
week
8,
is
9,
the,
10.
that's what I'm saying. Only 6 days, 4 days are there. We don't have any dates. It can be after Bihu only.
So, below than minute 2021.
22,
22nd.
22nd.
Yes.
Okay.
Massively.
With the concern of the other side, item number 42 and 44, lordship, that matter, lordship, maybe this is after, immediately after vacation, lordship.
42 and
44.
you have informed the other side.
Yes, yes, yeah.
Our plea is on 3rd May because he's only 71 years of age. Already 52 days. It will be by then only 54 days behind the family. Otherwise, we're not payable 71 years of age. So can be on 3rd May.
I will try. Data हो जाएगा कि मैंने डिस्टिंग पर आपने हले केस प्रॉब्लम हो जाए सब 7 can be. Instead of trial, she is soliciting on 7th. 7th of January.
Simply 60-day offense.
Huh?
Simply, I'm forgetting, might be a 60-day offense.
Oh, it will be over then.
I'm not
Okay,
sure.
okay, then it's okay. Then 3rd.
I'm not sure.
If it is over, then okay, it's 3rd only.
Only over, over.
Are they for 15, 5 minutes? On 3rd May.
3rd.
And I'd like to mention item 51 and 52 of supply.
50.
51 and 51. Lordship, a little bit accommodation, lordship. Can be
51 and
52, lordship.
Ah.
Can be taken at 2 PM, lordship.
no,
Otherwise,
there are lots of matters. If it reaches, then we'll take.
lordship, kindly see, ma'am.
No, I will see. But if it reaches, then definitely it's a bail matter. It may come.
Yes.
It may come.
Kindly try to add 2, lordship, because reference is there. That is why, lordship. Reference.
At 2 what? Before 2 also it may reach. Then, okay. As far as possible, we'll see. Otherwise,
May I please, your lordship. Lordship, supply item 43, lordship, may be taken out with item number 14 of motion, lordship.
14, 1/4.
114 is called lordship, then 43 may be taken out.
42 plus 43. No?
43. No, item 14.
14 along with 43.
When 14 is called lordship, then 43 may be taken up. Both are motion.
Council are same or different?
No, different. Council are different, case is same.
Acha, okay,
Much, yesterday I have mentioned.
okay.
Much obliged.
May this lordship, I actually mentioned item number 41 of the daily list. I'm seeking
41.
for some accommodation. Yes, lordship, 41.
Yes,
Your lordship, may kindly fix it a day after the Bihu break, lordship.
41.
41, lordship.
Was made by so and so for you. This after vacation. Okay.
Your lordship, may kindly fix a date, lordship. A date, lordship.
We don't have any dates such kind of. If you want any after Bihu, can be after Bihu will come. It will come after Bihu only.
Have your pleasure.
Item 1.
Shanti will.
Taken up here, my lord.
Which one? Which one?
Item 1.
We cannot say because at 2 there are different matters are also been fixed. We are rising by 3, so I cannot say.
Then my lord, time being as time being.
Okay.
Item 2.
Case diary may be called for.
His diary. When it can be fixed?
Lordship, can it be on 9th?
9th of January.
Yes.
9th of January will do.
With regard to item 14, my lord,
Yes.
this was, my lord, LCR is required on item 14.
Item 14, 1-4.
Yes.
Lordship, I have an instruction, Lordship, my on it, then Mr. M. Fukon will appear on this matter.
No, whatever. He's just submitting that LCR may be required.
Yes, ma'am. Only the LCR, they already search sheet has been laid down, my lord. So
Okay.
scan copy of the LCR is required. Search sheet laid down.
Just it later. We are calling for the scan copy simply afterwards.
Any
Scan
objection?
copy of the LCR.
Objection, right?
Huh?
I have. put
Any
that's
objection that
fine.
without PPI?
No, but he's just calling for the case. Diary. After Fukon appears, we'll let him know. Once that's ready. Yes. Scan copy of the LCR.
Item 14.
Date, I cannot say date. Yes, can.
After due vacation,
Before the
then 10th, Lordship.
That.
Yes.
obliged.
Yes, 43 was there.
Lordship, similar order.
Similar.
Lordship.
10th of January then.
Obliged. Value.
42, 10th of January को भी बात. 42.
Please, lordship. Yes, there may be call for lordship, NDPS lordship 22 feet.
Item 3. CD may be called for
Along with forensic report, lordship.
along with
Forensic
FSS. Along with FSL को भी बात. Yes,
It's 22C, Lordship, commercial quantity. Can it be?
it is not charge sheeted matter. So since when you are in custody?
2 days, 106 days, lordship.
106 days.
Arrested on 5th of September, lordship.
Then on 20th, Lordship,
20.
20.
20 will do. 20th of January because these are holidays otherwise.
Obliged.
Along with FSL को भी बात.
Item 4.
Wait, please, your lordship. Regular bail application, my lord. Assam Cattle Preservation Act, my lord. We were the driver and the helper in the vehicle, transporting 4 numbers of cattle, my lord. Now we've been in custody for 14 days. Vehicle has been recovered, cattle has been recovered, driver and handyman. So perhaps, my lord, further detention may not be necessary. After already what?
But sometimes it happens that maybe otherwise may be simple, may not be necessary also. But the question is that this kind of things is going on in fact. So let it be fixed on 3rd only, 3rd January.
Yeah.
Okay. See the 3rd January.
Item 5.
May I please, your lordship. The indication is lordship. Against the one lordship, Mohammed Paben and Billal lordship. And the allegation against the petitioner lordship, he helped the accused person in absconding lordship. That is the allegation lordship as per.
It is a case of কোনটো কৰি আছে আপুনি?
Five,
Item
Lordship.
five, Lordship.
Item number five.
Item five.
Item 5. Item 5 is a NDPS matter, I think.
Yes, Lordship.
Now, why absconding in sense? What are you saying?
No, Lordship. Whatever the allegation is against Lordship, one Mohammed Parvin and one Bilal Hussain, Lordship.
And you are not the Bilal Hussain.
My against allegation against me, Lordship, as per allegation forwarding, he alleged he helped the accused person in absconding, Lordship. That is the allegation, Lordship. I'll come to the forwarding, Lordship, page number 26. My name is not in the FIR, Lordship. I'll come to page number 26, Lordship, forwarding report, Lordship. May I read, Lordship? Effect of the ground of arrest, Lordship, I'll come to number 1. During investigation, sufficient evidence found against them and that they help absconding the main accused Bilal Hussain. This is the allegation, Lordship. And can I come to the Lordship, page number 29, Lordship. In rejection of bail petition, Lordship, from first line, Lordship. Although no contraband was recovered from the possession of accused Ariful Haq and Abdur Rahim, but from the case diary, it is found that accused Abdur Rahim and Ariful Haq were arrested by the IO in this case as they had helped accused Bilal Ali to escape. This is the allegation, Lordship. Lordship, the accused person has been arrested on 3/9/2024, Lordship. As on today, 47 days.
3/9.
3/11, Lordship. 3/11. As on today, 47 days, Lordship.
Since an organized crime, Lordship, city may be called for.
No, Lordship.
Might have some nexus, Lordship, we do not know.
Lordship, some heroin has been recovered from the house of the Bilal, Lordship, accused
Maybe,
Bilal.
Lordship.
Already, Lordship, the wife of the Bilal, FIR was arrested and released on bail, Lordship, after 33 days, Lordship. So whereas my name is not here, I am not involved in this case. Just allegation against me, the accused person helped the accused person. That is the allegation, Lordship. As on today, Lordship, 47 days behind the bar, Lordship, and it's not commercial quantity, small quantity, Lordship. So consider the details of your Lordship and involvement of the his not involvement is there, Lordship. It is reflected from the
See, it is an NDPS matter.
yes, Lordship, but
As she has submitted, actually
no.
it is an organized crime.
no, Lordship.
So we don't know what is there.
Lordship, I will come to FIR, Lordship.
I have seen the FIR, the forwarding also you have read already.
Yes, Lordship.
Now, yes, what is this?
My name is not there, Lordship.
So otherwise also, name may not be there, but what kind of nature, the modus operandi that has to be unearthed, the same, we have to go through the case diary. Lordship.
My lord, I maybe, my lord, allow item number 43, my lord, which was tagged with item number 14, my lord. Morning, A. Bora has mentioned, my lord. In item number 43, my lord, charge sheet has been submitted, but they have not approached the lower court, my lord. First, they have to go to the lower court, then they come, my lord. But in case of Vishal Fugon, my lord, item number 14, they have approached the, my lord, lower court. The lower court has rejected his bail application. Thereafter, they have come, my lord. But in item number 43, they have not approached the, my lord, the lower
Yes,
court.
Munir is there.
My lord, yes. So let it be, my lord, they approach before the lower court, then may come, my lord.
Because there is a forum, in fact,
My lord,
we
yes.
have override.
Lordship, I will have to operate instruction after some time.
My lord, it's such a, we have an instruction, my lord. Charge sheet has been submitted in this case, my lord. So
No,
further
they-
instruction, my lord, does not that.
No,
Procedural will be for.
not regards to submission of survey. He is saying that he wants to take the instruction whether they approach the trial court below. That is most probably his submission. I
My
don't know.
lord, but in his
This
petition,
is my submission, Lordship.
but in his petition, nowhere they have mentioned that way they have approached the lower court.
Let me add them, Lordship, different councils are there, Lordship, for appearing in lower court, Lordship.
Okay, let him just
My
take
lord,
in
yes,
first.
my lord.
Yeah. Yes, now he is saying that he is 47 days, then yes,
Yes.
other parts of submission. I think that now see, this is an NDPS matter. How can we say
Yes,
his
that's
involvement?
why
We
we are-
cannot say at this stage.
Lordship, already 33 days. When the
Third of-
FIR was already released, Lordship.
On 3rd of January.
Yes, already, Lordship, in the CD rejection order is clear mention, Lordship. After page of the CD, his bail application rejected by the lower court, Lordship. So it is clear, Lordship, his involvement. What is the involvement, Lordship? Only he
That's
helped
why
the
I'm
accused person as per
insisting on
allegation,
the
Lordship.
case
It's clear reflected in page number 29, Lordship. So I'm not a.
Otherwise, he is behind the bar for 47
Ye-
days.
yes,
You
boss.
may take instruction, otherwise what to do? On third, most probably his statutory will be over also.
Their lordship, on
What?
third,
Third, his statutory will be over, I think.
Lordship already it is 47 days, Lordship. So already I have provided copy, Lordship. After 33 days, FNM makes Lordship. This is the FNM makes Lordship. Who's recover the hidden work? This Lordship. Nothing has been seized from my position. I'm not involved. My name is not FR in the FR, Lordship. Thus, it is clearly reflected forwarding as well as rejection order, Lordship. That's it. It may be Harbour offender.
Lordship, mandatory period is not yet over, lordship, so how can we
Lordship, I have provided.
calling for the city?
Hmm?
So my objection may be recorded because without going through the city, we cannot say right at this moment. Lordship.
Well, it may be harboring offender, but not in NDPS laws.
But third, most probably his statutory
Ye-
will
yes,
be over,
boss.
I think.
Is the issue.
Yes.
And
That
a
is the
person detention period lordship. Because name is not fair lordship. Any condition lordship. I'll
So,
comply.
Lordship, let it be on tomorrow, lordship will take instruction.
We can give you some more time because FSL is whether collected or not, whether
Yes,
case
yes.
is ready for charging. That kind of instruction you have
Yes,
to
yes,
take,
yes.
you
At
can
2 p.m.
take
lordship.
at 2 p.m. Yes.
God bless.
Item 6.
Yes, item 6.
Okay.
It's a
43 application here.
Ah.
Lordship, NDPS case lordship, FIR page number 9 lordship, NXRA. FIR itself by the investigation. IO lordships wherein stated that lordship. May I please to read this FIR lordship. I'd like to inform you that on 10/12/2024 at 8:13 PM information has been received from the reliable source that some person who illegally possessed and selling suspected heroin physiotropic substance at New Star Unit 6 Beauty Spa Salon, Olobari, accordingly informed the matter to the IO Polton Bazar PS and general diary entry has been made. Polton Bazar PS GD entry number 22 dated 22 accordingly following people were detailed along with the assist into the case. In this
so registered under B or C.
the lordship. Yes, I am an employee of such.
It is B or C.
Lordship, it's 26, lordship.
22.
20 within bracket 6, Roman 2, and 21 within bracket 6, NDPS.
Roman 2 is the small quantity lordship, but
22, 6.
22, 6.
He's 60.
provision of 9.
Lordship, there is no such provision.
There is no such.
So what is
provision.
6? That's what he's confusing for.
Not. But
It
lordship
should be
section
20B, lordship.
B actually
It should
is
be
not
21
6, I
and
think.
20B. Strongly written.
lordship and lordship 21 is the manufacturing. I am not manufacturing.
Other suspected heroin, approximately lordship 9.28 gram. Ganja was wrapped in newspaper and 81
And
They are joint
commercial is
possession,
commercial in
lordship.
how
One
much?
is
Less than
9.2
commercial one.
and 81.0.5
9.28
and 81.0.5 grams.
then it will be almost commercial or what?
Yes, lordship, it's not commercial.
Not commercial.
Yes.
So I am
If it is
behind the bar,
ganja, lordship, if it is ganja, then it will be commercial, lordship.
It's a heroin ganja. What kind of thing?
One is heroin, lordship, that is 9.2528. That is smaller, intermediate, lordship.
Yes.
60 days of it, sports, lordship.
60 days of IQ lordship.
No,
But-
20 is 20B, I think. It's
Yes,
B, not 6.
20B,
And
not C.
21. 21 is heroin.
21 is heroin. So intermediate quantity, lordship, 60 days offense. So he is date of arrest is 10/12, lordship.
Call for the CD.
CD, lordship, along with the FSL, lordship.
So that may be given.
We don't have any short date now. We don't have any short date. 9/12. No, sorry, 9/1.
That is
9/1.
something. That is for you.
9/1.
9.
May please, Lord.
Yes.
Regular bail application, Lordship. Petitioner was arrested on 5/12/2024, as on today 15 days, and 21B of the NDPS is there also. Intermediate quantity. Lordship. At this stage, Lordship, the perhaps CD will be required.
When it can be called for?
Lordship on 8th,
8,
8, Lordship.
along with the FSL.
along with FSL, 8.
Obliged.
Item 8.
One of the charge sheeted case, Lordship, kindly also the actual. Scan copy, Lordship.
It's a POXO. POXO case.
Notice is also one.
Notice has to be. Notice to patai diyo. This one number 2 karne.
Lordship, I beg to mention item number 43 also. Okay.
My lord, here we have confirmed, my lord. In both the cases, my lord, before charge sheet they have approached, my lord. After charge sheet they have not approached. Here, my lord, they have their rejection order is 30/11/2024, but the charge sheet is submitted on 6/12/2024, my lord. So both the cases, my lord, before following procedure, they directly come before this one.
You make a submission then.
Well,
notice,
on
okay?
then, my lord, do one thing, my lord, without calling the LCR, let it be fixed on my lord on 10th month. So if LCR may be called for, they automatically come, my lord. Then lordship is bound to heart the matter, my lord, if come. So without approaching the lower court, my lord, they have directly approached this honorable after filing of charge sheet.
In my case, what happened, Lordship, 7/1, 7/11, we have filed, Lordship, and 7/12, we have filed this in High Court. And 6/12, the charge sheet was filed. At that point of time, we don't have any information, Lordship, regarding, because on 30, sorry, Lordship, on 30/11, our bail petition was rejected. On 7/12, we have filed here, Lordship, and they now says that on 6/12, charge sheet was submitted, Lordship. That's why we don't have any information. After our rejection, we directly came to High Court on 30/11.
That may be one of the
Yes.
ground that may be.
So let it be there. After charge sheet, they have not been approached. The after charge sheet scenario is different. So let it be come before this lower court, then they come, my lord. That is the procedure, my lord.
Then we can do one thing. If suppose, see, the scan copy receive also. In that case, if we will record your objection and then maybe direction for that may also be done.
My lord, yes, that may
That
be
can
return
be
the
done.
case, my lord, directly
That may
petitioner
be,
they approach
direction
the
may
lower
be
court,
there,
then they come, my lord.
direction may be there, otherwise we can.
My lord, much obliged.
Otherwise, just fixing on
10/1.
10/1. We are
Much
fixing.
obliged.
One is Vishal Pukon.
One is Vishal Pukon
Okay.
and second one is Sumi Bora, my lord. The main two accused, my lord.
Okay.
Lordship, much obliged.
Okay.
10th LCR, right?
Uh, 10.
No, that is fine, madam. We item 14 only, so 10th it is fixed for LCR, madam.
LCR now he
Yeah,
is
opportunity,
submitting
yeah,
before us, Mr. Fukon, that you have not approached before the learned trial court below after filing of the charge sheet. That is his submission. That's why let the LCR be called for. We'll come. We'll hear the matter if it.
That is correct, my lord, and there is no statutory prescription that one should file for bail before the trial court, my lord.
But there are.
Let the LCR come, my lord.
Okay, we'll see to it.
So on
Okay.
10th, LCR will come.
You can
Much
sub-
obliged.
Obliged.
No, Mr. Fukon, Vishal Fukon was earlier granted bail. That was rejected or what?
That is different case, man. That is Dibrugarh PS case 352. So it was transferred to CBI.
my lord.
And there are another two more cases there. One is Dulejan PS case and is Borbora PS case. That is in our state who is handling this case.
Total 3 cases. Lord.
And this matter which was, handed over to CBI, he is already bail on in
Yes,
that
yes,
case.
that is on the default bail. He has granted default.
Acha, acha. Now he is a hero at present.
Lordship.
Okay.
Much obliged.
Okay. Item 8, and we are calling for the
Scan copy.
scan copy. Scan copy, obviously it will be after vacation, I think. After vacation, in a sense, after Bihu it will come. How many? After Bihu. No need to fix any date. Okay.
They sometimes, Lordship, it helps us a lot to make.
On receipt.
Any date convenience to court, Lordship, date may be given.
24,
Lordship.
25 to fine.
Any day, convenience to court.
27.
Lordship, much obliged, your Lordship, much obliged, much.
Item 9.
May I please, your lordship, my lord? This is NDPS, my lord. This is, my lord, 170 grams more than the small quantity. My lord. Small quantity of ganja is 1 kilogram, my lord. So this is 177 grams more than the small.
It is B.
B in only 100 grams more than the small.
Date of arrest is on 7/12.
Yes.
Only 14 days, man. Case diary, my lord.
After BU only it will do. Yes. 9.
Yes.
Okay, case diary. 9.
Yes.
Obliged, highly obliged.
Along with FSL video. FSL. Okay, we are calling FSL also.
May I present, Lordship?
Yes.
Lordship, today is 37 days, Lordship. Lordship, allegation is 21B, 22C and 29, Lordship, NDPS. Lordship, this is, Lordship, case diary and
Yes,
FSL.
record. He is in 37 days custody.
Happy loss, 7 or 8. Lordship, today is 37 days, Lordship. 21B.
Commercial quantity, Lordship.
It's a commercial quantity.
No, Lordship, 21B is there, Lordship. My involvement, nothing is.
22C is also there.
22C is there.
Lordship is nearby Hategao, Lordship. Hey,
No.
not the matter
22C is
nearby
also here, not by
Hatigao.
Hatigao.
It's a matter of
22C is also there.
Commercial
Lordship,
quantity.
22B is also, Lordship.
So
Then,
on
Lordship,
20th, Lordship.
I'm just not, I could not follow you. What are you saying? 21B is obviously there. 22C is also there.
Lordship.
21 may be heroin, 22C may be the other drugs.
Nothing is seized in my possession, Lordship.
That may be one of the other.
Nearby, Lordship, Hategao, Lordship, 8 or 9, Lordship.
What 8 or 9?
January 8 or 9, Lordship.
10,000 numbers of Yaba tablets.
Yaba tablets are there. Could be after vacation only, after BU vacation.
Yes, Lordship,
22.
21.
21.
Obliged,
It's a
Lordship.
commercial quantity. 21.5 along with FSL report. 21.5, no, 21.1. What have it, parables? 11.
May I please, your lordship? Allegation is under section 21C of the NDPS Act, my lord.
Your petitioner is behind the bar since when?
Since, my lord, 1st of August, my lord.
1st of August. September, October, November, December. 5
100
months
first of
already
August.
gone.
Yes.
And
141.
CD, Lordship, on 10th.
10th.
Yes. Along with FSL.
Along with FSL.
Okay. Well, 10 is some difficulty, my lord.
10 what?
Any-
You have some difficulty.
Yes. Any date, my lord?
Be
Nine-
corrected.
Is the date?
Yes.
My lord, yes,
28th, Lordship.
20, my lord.
20.
20.
Okay.
Well.
Your lordship. This is a search matter, your lordship. I was, well, the petitioner was arrested, while he was in custody and during pending investigation, I was granted bail by this Honorable Court in terms of the bail application filed by the accused. And after that, my lord, search sheet was submitted. After receiving someone, I appeared in this case. In the meantime, during the appearance stage of the other accused, he was arrested in another case, Because of that, I was prevented from appearing in this case. And accordingly, the counsel who was engaged in this case, he also unable to take steps. Accordingly, NPW was issued against the case. And after that, when I came to know about his arrest, I approached to the counsel approached to the learned court below. And after that, he was arrested in connection with another case. And in terms of that, as per 9/4/2024's orders, he was taken custody in connection with in this case, based on the NPW. Now he's behind the bar from 9/4/2024. The trial is at the stage of the appearance stage also. And the person who was accused is suffering from tuberculosis and is admitting at LGBT sex hospital from 12/8/2024. I attached the copy of these orders basing on the report submitted by the medical officer. Lordship, my parents is page 43 onwards is the order.
These are the receipt, medical documents.
Lordship, this is the order when reflected about the his ailment suffering from tuberculosis basis on the report submitted by the medical officer. Page 43 onward.
Now cases of what kind of nature of case?
NDPS lordship, it is intermediate quantity. Lord. 70 grams of heroin was recovered from one surgically, not from the present pedicine.
And what is the, in the other case where you have already earlier arrested, that is same nature of case,
Same
NDPS
method-
only.
Same method of case. In that case also, I was not, it was not recovered from me. Lordship. I was the invitee and I went there, the police has come and
So you have some criminal antecedents then. It's not that it is the first
it is
case.
subsequent.
Whatever.
This is first case and the
Other one is
other was
subsequent.
subsequent. It 2000
Whatever.
and the person
Criminal background is there.
subsequent lordship, he is a tuberculosis patient and admitted from 12/8/2024. So, scan copy of the LCM will be called for a date will be fixed on.
No, regarding that you were arrested in connection with other case.
Sure.
That matter could have been produced, produced before the learned trial could below that these are the condition. That's why
No,
I was not in a position to appear.
I have already applied to the court and I also petition that was rejected. And accordingly, in terms of order dated 9/4/24, I was taken imam in this current state.
Here.
Yeah.
So now in this case, presently, since when you are in custody? 9/4.
April 2024. Also, I have annexed page 742.
For this scan copy can be called for.
Yes.
A short date may be given because he's a tuberculosis.
Short, we
patient.
don't have the.
January 7th of January. His admitting
Otherwise,
is
what
August.
happened in such case as he submitted, Mr.
Lost.
Borga? Such kind nature of cases, what happens that if a person is behind the bar for in other connection with other case, generally court considers because it is a ground
Yes,
because he is not prevented from appearing
Yes.
as because he is, but his counsel most probably failed to take any steps.
Yes.
Otherwise, what has happened if the number was there with the case number or in which connection he was arrested,
Yes.
then the production warrant can also be issued for production of the death. Then it will be regularized for him. But most probably that was not done due to fault of his counsel, I think.
Yes.
Okay, we are calling for this. We want to fix it on 7th. Scan copy of the LCR we call for, fix on 7th. Okay, we are fixing.
All right.
30.
May I please?
Yes.
Recovery of rhino, allegation is recovery of rhino horn. Lord.
Rhino horn.
Yes, Lord.
Now here you are appearing. PP Assam is there. It's a case of recovery of rhino horn. Bora, you are appearing here. Item number 30.
Arrested by police.
Police.
Yes,
sir.
doctor.
Oh, then you can appear.
Yes. Otherwise, wildlife.
Well,
Yes, sir. That's why I'm asking you.
Yes. Special PP is there, lordship. So be sure now.
But most probably arrested by
Police.
police.
PS case has been registered. Lordship.
On subsequent date, we can inform him that he may appear. But presently, your petitioner is behind the bar since when? 5/12. 5/12, he got arrested.
Yes.
yes, yes, Lord.
CD may be called for at this stage. I'll let the learned counsel. Mr. B. Sharma, special PP wildlife.
And
Mr.
also,
Bishop.
forensic is also, I think, necessary.
It has, as per your knowledge, whether that has already been sent for examination?
No, I don't know. I'm not there.
So let the matter be possible for the time being. I'll inform the concerned person. It'll be all right.
Whether he will appear because state is party here.
Since
And
wildlife.
as police arrested and the case is investigated by most probably
Okay,
police.
lordship, call for the case to be along with the FSL report. So if it is necessary, then I'll inform the.
When it can
concerned
be fixed then.
Lordship,
21?
21.
Yes, of like.
Along with FSL.
45.
Yes, 45.
Need please, your lordship. Lordship, FYI is in page number 12, lordship.
Petitioner is behind the bar since 1 year, lordship, 1 year, 10 months. So
Is it charge sheeted one?
Charge sheeted matter, lordship. Scan copy required.
We call for the scan copy. It's a commercial quantity case. Scan copy of DL shall be called for. Will be obviously after view vacation.
Yes.
Can it be after? After view vacation will do?
Lordship, yes.
If you don't
can it
fix
be on
any date?
4th, Lordship, 4th February.
4th February.
Yes, 4/2.
Obliged, lordship.
46.
Forty-six and forty-seven,
Yes.
the
46.
applications made for first time being rejected. Acquisition on the.
Rejected by this court.
Yeah, yes, by
Achha.
this, that is why it is,
Achha.
petitions of prayer lordship. I am behind bars for more than 12.5 months. And, the principal ground of rejection on the first occasion was the non-examination of victim and informant. Those have been done.
Those have been done.
Those have been done.
So then we call for the scan copy of LCR. After Bihu will do, after Bihu vacation. Because prior Bihu only 4 days are there.
Yes,
These
yes,
are
only
already
4 days are
preoccupied in
left.
fact. 22nd or 23rd will do.
Well,
23rd.
the service, if it can be effected through the police, why not?
Oh, yes, you have to issue notice also. POCSO matter, na?
Yes.
Sorry. POCSO itu case to puri dibo. No, it will be effective through police only.
Yes.
To judicial police station. That is the
Yes.
now practice.
Yes.
It will be routed to the office of the registry, then to public prosecutor. Public prosecutor accordingly sent. And in that case, service of summons, public prosecutor can make an inquiry also in that regard regarding the service of notice. So otherwise, we are sending the record and we are fixing it on 23rd of January.
Much of this. Much.
So, but you take steps, timing, I don't step over. Office will be reopened. Office to khula thakibo apnalok. To take steps immediately, otherwise it will not reach. Yes. By tomorrow or by Saturday, you take steps.
Much obliged, ma'am.
Lordship fixes any dates.
23rd.
Both the cases, 46 and 46.
Yes.
Obliged. 50.
5. 1. Fine.
Please, your lordship.
Achha, 1 5.
That's it. Well, this
Yes.
is a revision petition. My lord will find the impugned order at page 41. The petitioner is before your lordship. This is a murder case, and the petitioner is before your lordship has raised the plea of juvenility before the learned trial court, and accordingly they had annexed their metric admit cards, and one of the petitioners had submitted his certificate. The other, he did not pass the exam, so he could not submit the certificate. He submitted a transfer certificate, admit card by both, and one the pass certificate, another transfer certificate. Now, your lordship will kindly come to the order, page 41. May I read the order now?
Yes.
Accused persons, namely Kuzrat Ali Sheikh and Munwar Hussain, have filed petition number 1578 of 2024 under section 7A of the Juvenile Justice Act 2000, praying to declare them as juvenile in conflict with law, and also submitted relevant document along with the petition. Heard learned counsel for both sides, peruse the case record. Both the accused persons have submitted admit card issued by Board of Secondary Education of Assam for High Madrasa Repeaters Examination 2000, wherein the counter signature of the officer in charge of HSLC AHM examination is completely illegible. So the documents of both the accused persons cannot be accepted. Secondly, since the certificate issued by the Board of Secondary Education Assam for accused Munwar Hussain is based on admit card, so the same cannot be accepted. Moreover, the school certificate of Tapar Higher Secondary School for the accused Kuzrat Ali has been procured on 29/3/2023, which creates considerable doubt in the mind of the court. Accordingly, the same certificate also cannot be accepted. Considering all aspects, and prayer for declaring juvenile in conflict with law is hereby rejected. So, my lord will kindly see our documents. My lord will kindly see page 37. I also have the originals, my lord, if you also want to see those. Page 37 is the admit card of petitioner number 1, Monwar Hussain. Near, my lord, that counter signature is an old document, my lord. Because of this reason, the court has rejected. Same with page 39, the admit card of Kuzwat Ali Sheikh. So, my lord, law under section 7A is very clear. As soon as the plea of juvenility is raised, the court has to conduct an inquiry. Now, if the court was otherwise not satisfied with these documents, the court should have conducted an inquiry. The court could have called the relevant registers from the SEBA to verify, because plea of it's a murder case. Plea of juvenility is that is a very serious issue, and the law is very clear. Law, section 7A of the JJ Act clearly says that whenever a claim of juvenility is and it will have the 2000 Act, because this is a 2000 Act case, man.
Oh,
So this 2000, it will be there, man, in this book also. It will be
yes,
there.
yes, sir. 7A.
7A, man, okay, 2000 Act. Also has something. Yeah. Whenever a claim of juvenility is raised before any court, and the court is of the opinion that an accused person was a juvenile, or the court is of an opinion that the accused person was juvenile on the date of commission of the offense, the court shall make an inquiry, take such evidence as may be necessary, but not an affidavit, so as to determine the age of the person, and shall record a finding whether the person is juvenile or a child or not, stating his age as nearly as may be. So the law mandates that an inquiry has to be done. We have given our documents. These are genuine documents. But if the court was otherwise not satisfied, it was incumbent upon the court to call the appropriate authorities from SEBA, call for the registers. They could have verified. If after verification these documents are found to be false, then there was no issue. Then the court could have rejected. But when I have produced documents, these are matriculation documents. Just because the counter signature is not legible, these are documents of 2000, my lord. And I have the original. If your lordship is inclined to look at it. These are the original documents, my lord. So these are old documents, my lord. And some amount of counter signature, if it has become illegible, that should have been verified instead of outrightly rejecting my juvenile plea, my lord. So at this stage, my lord, what I am humbly submitting is that, my lord, the learned trial court.
Date of birth is, I don't know what is this.
Date of birth is, my lord, this is the incident of 98, my lord. So petitioner number 1, he was 16 years and 23 days on the date of the incident. Petitioner number 2 was 16 years, 7 months and 1 day. So what the trial court should have done was conducted an inquiry. And this was also not cause delay because the trial itself has been stayed by this honorable court. The trial itself is stayed. So the court could have taken some time and conducted an inquiry.
Your two petitioners, sir, one is Nasib.
One is Monwar Hussain, my lord. Monwar Hussain.
Oh, Monwar Hussain.
Monwar Hussain. The other is, my lord, Kuzwat Ali Sheikh.
For Kuzwat Ali,
admit card, and because Kuzwat Ali did not pass the exam, his transfer certificate from his school. Monwar passed the exam, so his certificate. Admit and certificate. Page 35 onwards, 37 onwards. Which Kuzwat Ali did not pass, this transfer certificate was subsequently procured, but admit cards of both are issued at the normal time, the usual course number. So
yes.
let the trial court make an inquiry, my lord, and then if no material is found, it may be.
This case, lordship notice should go and answer may be called for lordship.
Okay, see, it may be not it may not be legible, that is true.
Because no, if
So,
LCR, on the point of LCR, because this is only confined to the plea of juvenility, we have already annexed our petition. We have annexed our documents. We are not going beyond anything, beyond the plea of juvenility. And this is a 302 case, so otherwise informant is not required to be heard on this plea. My limited submission is that let the court conduct an inquiry. I have produced the document, court is not satisfied. Let the court call the relevant registers and the documents. If my documents do not tally, it is going to be rejected. But endeavor may be made, madam.
otherwise
That
it
can
is
be done within
rejected only on the basis that it is
Not
not
legible,
legible.
not legible.
That should not be, I think.
Provision, by specific provision.
Yes,
That
yes.
And this will not cause delay because trial itself has been stayed by this honorable court.
Already
Stayed,
stated.
madam, page 30,
Page
30, madam.
30 to নতুন কেস দেখুন page 30 এটা আর বুঝতো না। এটা আগে যেটা হবে এটা আর এটা নতুন হবে। তার মানে এটা বেলেন তেমনি
No, that's in another case, madam. Separate criminal petition.
oh that's
Not in this petition, madam, in another petition.
another petition for these two accused persons or
One accused person. One of this petitioner and another accused, because there are multiple accused in this case. So they had come because defense evidence was closed. And that is why they preferred a revision. In that case, my lord, proceeding, because it was at the last stage, so proceedings were stayed, my lord. Now, as far as this plea is concerned, my lord, this aspect will be considered because this will also not cause any delay.
no but otherwise the case is at the stage of
Defense
defense
evidence.
evidence.
Defense evidence.
313 already recorded
313 already recorded, madam.
and in your 313 what is your plea, have you filed, I mean not plea, age you have
This plea of, well, we gave our current age, my lord, in 313. 313, we only answered our questions.
yes, yes
But after defense evidence, at the stage of defense evidence, we raised this plea, my lord. Lordship knows that plea of juvenility can be raised at any stage. At the stage of defense evidence, we raised that plea, my lord. Now, our current age we have given in our 313.
Lordship may direct to make a fresh inquiry. Lord.
Fresh inquiry.
Yes, sir.
heard Mr. S. Namas, the learned counsel for the petition, and also heard S.H. Bora, the learned representing people being the opposite respondent. This revision petition is filed under section 438 and 442, read with section 528 of BNSS. For setting aside and portion of the order to be 13/11/2024, passed by learned additional session judge Bilasi Para in sessions case number 43 of 2000, wherein the plea of juvenility of the present two petitioners were rejected. It is submitted by Mr. Nawaz that both the accused petitions were juvenile at the relevant time of incident, and accordingly at the stage of recording of evidence, recording of DW, the two petitioners took the plea of juvenility and filed the petition before the learned trial court, along with some relevant document to show that at the time of incident, these two petitioners were juvenile. In support of the plea, they have the admit card, and other one is admit card, one is pass certificate.
One is for petitioner number 1, admit card and SEBA school certificate, SEBA certificate, SEBA pass certificate.
SEBA pass. For petitioner number 1, the admit card and the birth certificate of matriculation issued by SEBA was produced, and for the accused petitioner number 2, the admit card and the school certificate was produced to substantiate the plea of juvenility. But by the order dated 13/11/2024, the learned trial court below had rejected the prayer.
Page 41, madam.
rejected the prayer of juvenility with the observation that the admit cards which were produced before the learned additional signatures, comma, the signature of the examiner of is completely illegible, and also consider that the certificate issued by Board of Secondary Education for the accused petition number 1 was only based on the admit card issued, admit card and admit card, full stop. Moreover, it was also observed that the school certificate produced for the accused petition number 2, namely Kuzrat Alisi, was procured only on 23/09/2023, and which also creates a reasonable doubt in the mind of the learned additional section judge regarding the genuineness of the plea of juvenility, and with that observation, their prayer was rejected. Mr. Next prayer, Mr. Navas further submitted that as per provision of section 7A of JJ Act 2000, the learned court below can make an inquiry in regards to the plea of juvenility, and is accordingly he submitted that the further inquiry can be made by the learned court below by calling the registrar from the office of the Board of Higher Secondary Education, Board of Secondary Education, to prove the to see the to see as to whether the documents oblique the admit cards which were produced before the learned trial court below are genuine or false wrong. Next paragraph. MS Asad Bora submitted in this regard, then that the learned trial court below may be directed to make an further inquiry in regards to juvenility of those two petitioners, and accordingly the direction may be given. Next paragraph. Hearing the submission made by learned counsel for both sides, I have also perused the documents, that is the admit card and oblique admit card and the school certificates, oblique pass certificate, etc. And the original is also produced by the learned counsel. And accordingly see that there may be the signature of the controller of examination may not be so much legible, but only on the basis of that the plea of juvenility cannot be rejected, wherein both the petitioners were produced the admit card, which is considered to be a very relevant document for consideration of age. Accordingly, I find it proper to set aside the order of 15/11/2024 in regards to rejection of prayer of juvenility, and the learned additional session judge is hereby further directed to make further inquiry in regards to further inquiry by calling the registrar from the Board of Secondary Education or any other officers which is deemed fit to be examined by the learned trial court below. With that observation, this closed on. The copy of copy what it was Jabo.
So we'll provide the certificate. I'm deeply obliged.
See?
Wait, please.
Yes.
Lordship, this is an application for zimma of a commercial vehicle, Lordship.
Commercial vehicle.
Commercial vehicle, Lordship. Page number 16. Registration certificate, Lordship.
Page number
16. 16, Lordship. If the vehicle was seized on 9/8/2024, Lordship. Subsequently, the petitioner filed for interim zimma petition on 2/9. On 2/9, the zimma after receiving the report from IO, the zimma petition was rejected.
Where is the order?
Lordship at page number 21. Lordship, impugn order is 27. Lordship.
27 is a rejected.
Impugn order. Lordship. Before rejection on 27, Lordship, 39/2024, earlier 2 times was also rejected, Lordship.
On what ground?
Same
Considering the
ground,
report of the
Lordship,
IO.
Same ground, Lordship. Lordship, kindly finish page number 22, Lordship.
Twenty-two.
22. 22 and 25, same ground, Lordship. Investigation is not completed. Lordship, the vehicle purchased by the petitioner on EMI, Lordship. So as on today, 133 days, the vehicle is laying on the police station in open, under the open sky, Lordship. So, Lordship, as per Shondor by Angala, judgment, Lordship.
Is there any report from the IO that
Lordship.
any confiscation or any
No,
proceeding is
Lordship, already
initiated?
seized goods already been auctioned, Lordship.
Auction.
Already auctioned.
No, regarding the vehicle.
Regarding vehicle is laying on the police station.
That's what I'm asking, whether is there any initiation of the process of confiscation for the vehicle also? No, not yet.
One accused was arrested and subsequently he was released on bail, Lordship.
That is different thing.
Lordship.
You are not the accused.
No,
You are also one of the accused.
Lordship. No, I am not. My
You are
name
not
is
the
not there,
accused.
Lordship. My name is not there, Lordship.
Case is already charged sheeted.
It is not filed yet.
The Lordship may call for a report from the IO. Final report.
Shortly, kindly pay with the page number 21, 25, and 27. Same report is submitting by the IO, Lordship.
Lordship, page 27. Third paragraph, Lordship.
Okay.
Learned counsel for the petitioner has submitted that the vehicle belongs to the petitioner and he may be granted zimma. And but the learned APP submitted it from the report of the IO. It is apparent that the vehicle is required for investigation and the petitioner has not cooperated in any way during the investigation. So there is an adverse remark on the
Lordship.
So why don't you?
Same report also submitted earlier 2 times.
No. Why you have not cooperated? I mean, you can approach the IO also.
Lordship, I had approached, Lordship. I had approached, Lordship.
Because your vehicle was
Lordship, kindly
seized
finish-
along with those goods, in fact.
Lordship, kindly finish page number 27, para number 2. The IO in his report has submitted that the vehicle bearing registration number so and so is registered in the name of petitioner Fakir sir, as per official record. I have submitted my RC Xerox copy.
The order also reflects page 28, Lordship.
Lordship.
The seized vehicle is a part of active investigation and there are relevant materials submitted by the IO for its requirement for ascertaining the actual ownership and further investigation. So Lordship.
The actual ownership, he is registered owner.
Yes. So at this
Otherwise,
stage,
also
Lordship,
there is that the vehicle, I mean, the petitioner is the registered owner.
Yes. So
At this,
Lordship,
we can call for the report, but otherwise it seems that.
present status report, whether it is required for further investigation.
Call for a report from the IO as to whether the vehicle is required for further investigation, which is another investigation. Reported out for corporate. Yes. Heard so and so corporate. We are calling for a report. Let us see.
Short date may be given.
We don't have
Immediate
any
after
short
vacation.
dates. Huh?
Immediate after vacation.
Immediately after vacation will be the order. It may put up immediately after vacation.
Date may be 4 or 5.
No date is there.
January.
That's why I'm saying no date is there.
May it please your lordship.
Yes.
Lordship, this is a revision petition, my lord, against the order where the petitioner has not been allowed to dispose of the vehicle. Zimma already given, my lord. The vehicle is already with the petitioner who happens to be the owner. My lord, the FIR is at page number 9. The FIR is with regard to an accident which had occurred with the present vehicle with a magic car, and my lord, the accused is the daughter of the petitioner, my lord. A few years ago, the Rajpurna Golo incident, my lord, the mother is the petitioner here. So basically, after the matter, the accused has been charge sheeted, my lord. Now charges have been framed in the year 22, but however, till date, out of the 23 witnesses, none of the witnesses have come, my lord. So every day after day, it's going for evidence. It's been more than 3 years. Then subsequently, my lord, page number 13 is the vehicle registration certificate, which shows that vehicle number and that the present petitioner is the owner of the vehicle. Page number 13, my lord. Case presently is at trial stage. Evidence has started, but not a single of the 23 witnesses have been examined. Then, my lord, at page number 14 is the zimma order, my lord. On 10/3/22, that is 2.5 years back, my lord, on the zimma application by the petitioner, by verifying that the petitioner is the owner of the vehicle, the zimma has been given. At page number 14, lordship may see the last line, my lord. Hence, considering all and the interest of justice, seized vehicle can be given interim zimma to Mrs. Jyoti Bola. So she has taken zimma of the vehicle. The vehicle was taken to the garage. The vehicle is of the make, my lord, Chevrolet Aveo. That Chevrolet company has shut down in our country, my lord. So, and owing to the damages and no parts being available, insurance company and company, all vehicle manufacturing company, as well as garage has stated that there's no point repairing this vehicle. The vehicle is presently is only use that can be of, that is of scrap, my lord. At page number 16, my lord, this is where the vehicle is parked, my lord. This is the bill. That is one bill, for example, I'm showing, my lord, that the petitioner has already incurred 40,000 for parking the vehicle. Because to dispose of the vehicle, the court's order would be required. So as such, my lord, she's incurring every day, my lord, I think it is 200 rupees for parking the vehicle in the garage. Then the pictures of the vehicle are annexed, my lord. It is destroyed beyond repair. So owing to this, my lord, that is where the impugned order comes in at page number 25, lordship. That is 9/8/23. The petitioner approached the trial court stating the grievances that this has happened. The vehicle is beyond repair. Company has closed. I need to dispose of the vehicle as scrap in a government scrapyard as permissible by law. But the trial court also, my lord, yes, because there is a legal paradox that a court, once an order is passed, cannot review. So the learned trial court, owing to the, my lord, statutory bar, has stated that, my lord, that is on page number 26. It is seen on perusal of the case record that while ordered dated 10/3/22, the said vehicle was given in zimma of the petitioner Jyoti Bora with conditions that she will produce the vehicle as and when required by court. The case is at the stage of evidence. Prosecution is yet to examine any witness in this case. Today also might not same. After 1 year also, no witnesses have till now turned up. Allowing the petitioner dispose of the vehicle may adversely affect the trial of the case. So that is the case of the petitioner, my lord, that she may be allowed to dispose of the vehicle in a legal manner in a government scrapyard, my lord. Because MBI report is already in the case record. Vehicles photographs are already there. Every day, my lord, she is a retired employee, my lord, librarian of the legal remembrancer. She's a senior citizen, widow, and every day she is incurring these expenses. And my lord, the accused will face the consequences, who happens to be a daughter. But my lord, this lady is suffering, my lord, needlessly, my lord. So, my lord, the intervention from this honorable court is required that the vehicle may be allowed to be disposed of in a proper manner in a government scrapyard, my lord. That is the simple prayer, my lord.
While releasing your vehicle, what was the bond amount, in fact? We have executed a bond, I think.
Yes, my lord. The bond of 3 lakhs, my lord.
Then
that
bond was there because it was a temporary zimma. So that's why the bond was there. So now what will you do?
But it's the same bond. The bond still will exist, my lord.
Bond, how bond will exist? Bond was there that you are to.
Yes, my lord.
As and when it is required, you are to.
My lord, with direction that the petitioner will not, my lord, dispute the ownership of the vehicle. That is the simple role of the petitioner, that she will not dispute the owning of the vehicle. Well, because it might take another 8 to 10 years, my lord. Probably 5 times the value of the car this lady will have to keep on bearing, my lord. Trial court is also burdened, my lord. We understand that.
Because it was a condition in fact. What to do?
That is why we come to revision, my lord, because the trial court, of course, cannot review its own order, my lord.
What to say? Oh, your problem is, I can understand, it's a
My
general
lord.
problem.
thing
Because
is that-
paying a 200 per month or whatever.
Daily, my lord.
Still. Trial proceeding is yet to be initiated. If it is, there is a condition as by order dated 10/3/2022. So, as and when required, it has to be produced actually during the time of trial. That is the only issue. Otherwise, on regular basis, you have to pay the entire 200 per bus, 200 bucks per day.
Some distance. So by keeping proper photographs, my lord, detailed photographs from all sides of the vehicle in the case record, which already is there. But my lord, for further assurance, again, photographs will be submitted and then my lord, the vehicle may be disposed of, my lord.
Otherwise, we don't have any alternative. Otherwise, that may be one of the option.
My lord. I leave it to your lordship's wisdom, my lord.
Is anything to submit? The problem I can understand. It's a
Yes.
very
My lord,
problem.
my lord, that is where the paradox, my lord, that bond is there, my lord. Yes, of course, zimma is always temporary, zimma, my lord, with bond. Trial court was also correct at the time of zimma. But this, my lord, unforeseeable circumstances came up, my lord. The company closed down, vehicle is beyond repair, and that has to be parked in a garage. By keeping proper photographs, my lord, with government scrapyard, by keeping proper records and photographs, I may be allowed to dispose it in a government scrapyard, my lord. That is my prayer, my lord.
So case was pending since when?
My lord, cases been pending since the year 21, my lord. Zimma was given in the year 22.
No evidence is recorded. No evidence is recorded.
No, not my lord. Not my lord. Today also, my lord, the informant was called. He was a retired. Today also, my lord, trial court it is fixed, my lord. Obtain instructions, my lord, from the appearing counsel. Sessions case number 17/22. No witness has come up, my lord. Next date again will be on the month of February, my lord. The trial, my lord. The
Otherwise,
daughter trial
it's the case of 304A or what?
304, my lord, yes, because in the FIR there's no 304 because the person had not died. Subsequently, 1 month later, for whatever reason, my lord, subject of trial, because of the
Died.
death of a person, 304 was subsequently added in the charge sheet, my lord. So the daughter is facing the trial.
Okay, I'll think I'll pass the order somewhere.
Lordship,
Because,
lordship's wisdom, my
understand.
lord.
Yeah.
This lady, but she's not the accused, so my lord, what is, my lord? We told it,
Okay,
my
we'll
lord, I
check.
pray. Oblige, my lord.
Pass the order. একটু লিখে বইতে লাগে dispose sign order to devote the duty. It's no order dispose লেখা হবে. Order will be there.
My application, the criminal petition, my lord, FIR page number 14, my lord, that is NSR 1, my lord. It is a charge sheeted case, my lord. Trial is going on, my lord. Now present is the appearance, my lord, in the trial court, my lord. In this case, the 5 number accused, my lord. Already 1, 2, 3, my lord, FIR name accused, my lord, already released in regular bail and appearing regularly in the trial court, my lord. This present petition for, my lord, the FIR name accused number 4 and 5, my lord. We are the sister of the prime accused, my lord, that is Procedural Rahman, my lord. It is the 304B, my lord, suicide case, my lord. Now we have to appear the trial court,
Why
my lord.
304B then?
My lord,
If it is suicide?
Yes, my lord, the wife of the Procedural Rahman, FIR name.
Well, it's dowry date.
Dowry. My lord, we are the sister of the prime accused, my lord. We have to just appear the trial court, my lord. Now it is required to protection, my lord, because absconding swing against us, my lord. Absconding swing in charge sheet, my lord, against us, my lord. That is why, my lord, it is required to protection, my lord. We have to appear the trial court, my lord. Face trial, my lord. That is the simple prayer, my lord. Just protection need, my lord. We are ready to face the trial, my lord, and we will appear the trial and face trial, my lord. But
You are showing as an absconder in the charge.
Yes, my lord. Yes, in charge sheet, my lord. Here is a reason, my lord. explanation, there is a reason, my lord. Much earlier, there, my lord, the incident, my lord. Already we are the married, my lord. We are the residing at, my lord, matrimonial house, my lord, not Pandal, my lord. My lord, at that time of investigation, my lord, police came the, my lord, Pandal house, my lord, and not test out us, my lord. And because we are not available at that moment, my lord, we are already married and we are already residing at our matrimonial house, my lord. Police came, my lord, in the Pandal house, my lord. That is the problem, my lord. It is clearly showing, my lord, in charge sheet, my lord. Page number 22, my lord. Kindly see, it is clearly showing our addresses, different address, my lord. Page number 22, my lord. Last part, my lord. Page number 20, last part, my lord. Hence, it is clear that the kindly issue enrollment is the charge sheet, my lord, extending the approach Aklima Bibi alias Alima Bibi. So, and so, my lord, of the Bisondoi, my lord. According to FIR, my lord, place upon the North Raipur, my lord. There is a gap, my lord, distance, my lord, at least 30 kilometers, my lord. It is clearly mentioned, my lord. We are residing in the separate place, my lord. That is why, my lord, extending showing, my lord. Showing, my lord, in charge sheet, my lord. There is a minimum. Now, my lord, kindly see the page number 33, my lord. Page number 33. Page number 33. It is the court's order, my lord, trial court, my lord. Akush Fazilur Rahman, Ansar Ali, and Fazilur Bibi are present. They are appearing regularly in the trial court. Now, my lord, co-accused was absent with estate, my lord. My lord already engaged counsel for us, my lord, already is regularly appearing, my lord, before the trial court, my lord. Just wait for our, my lord, appearance, my lord. Just its needs, my lord, require, my lord, the protection, my lord. We will appear trial court, my lord, face trial, my lord. And we did, my lord,
Still now, no NPW is issued against you.
No. Just for fixed for appearance, my lord. It is clearly mentioned, my lord. Appearance for appearance, my lord. Fixed for appearance, my lord. And our engagement is already appearing, my lord, before the trial court, my lord. Just taking time by taking time, my lord. Simple grammar,
Yes.
we are.
But my learned friend, where is something else, Lordship, for pushing the entire criminal proceeding?
Entire criminal proceeding?
Yes.
No, my lord, that is not going to fund, my lord.
Huh?
My lord. Just protection is, my lord. Interim protection, my lord. Kindly see the page number 12, my lord. Page number 12, my lord.
And the search sheet is question of search sheet.
No,
It is first and everything.
No. Page number 12, my lord. Clearly mentioned, my lord. Page number 12. Kindly see page number 12.
In that cost title, Lordship.
Page number 12.
You want
my lord.
to pray for the entire criminal
No, my lord. It's just interim protection, my
No,
lord. Page
you
number
are saying
12.
no. Your petition says yes.
Yes, my lord. Page number
Then-
12, my lord. Page number 12, my
12,
lord. It is mentioned.
12 we leave, we forget about 12. Your title cost title.
No, my lord. It is wrongly, mistakenly typing, my lord. My lord,
How
interim
can we
protection.
say wrongly, rightly? What is you see? See the cost title first.
No, my
What
lord.
is-
It is not possible the quashing the tile.
No, we can, how can we say no, yes, it is there, it's a.
Kindly see the my lord, once the my lord. Page number 12, my lord. Page number 12. It is clearly mentioned. 12, my lord. Page 12, my lord. Kindly.
Amend the cost title.
My lord, page 12, my lord. Kindly see page number 12, my lord. Page 12, my lord.
Mm.
In name of it is for the prayer that the pending disposal of petition, my lordship, may the father please to allow the interim protection, my lord. Interim protection, my lord, so that till the next day.
That's
That
what
is,
I
my
am
lord,
saying,
20
cost title.
January, my lord.
Cost title will be amended. Amend the cost title. We can
Yes.
pass the orders that kind of thing. Your entire cost title is for
So,
quashing.
my lord, I will file my lord, additional affidavit, my lord, in the maintain, my lord. Please, my lord, another and call for another copy, my lord. I will file my lord additional affidavit, my lord.
No, we cannot forget it is already
No, my lord,
wrong.
it is my lord, clearly mentioned, my lord, the protection, my lord. It is clearly mentioned, interim, my lord.
Cost title is.
Cost title is not
Maybe
correct.
change
No,
for-
you see your cost title first. See your cost title. Amend this one.
Please.
You're not saying that we are not pass any order. Amend this one. And by the time, particularly next date, you may file a petition through your counsel seeking time. Because till that NBW is not issued against you.
Yes.
And with such kind of NBW, your protection may be there, but the question is your cost title itself is wrong, in fact. It should be amended, huh? It has to be amended. Hi, Mr. S. Rahman, the learned counsel for the petition. It is submitted by Mr. Rahman that the Casino case is filed for some kind of interim protection so that both the petitioners who are shown as an absconder in the charge sheet may appear before the learned trial court below. But on perusal of the record, it is seen that in the cost title, the prayer was made for. In the cost title, the present petition is filed for quashing of the entire criminal proceeding, being PRC case number 1060 of 2023. Accordingly, the petitioner is hereby asked to correct amend the cost title of the petition And accordingly, the matter may be listed after correction of the amendment of the cost title. You can file an addition,
Madam,
what
in the-
manner you want.
My lord, if possible, my lord, first week, my lord, in the first week, my lord, because trial court date fixed on my lord, 20 January, my lord. I will file my lord before vacation, my lord. My lord,
Before
fix my lord, 8 or 9, my lord, maybe.
8, we are fixing.
If possible, my lord, put interim protection, my lord, if possible.
Your
If possible, my
petition
lord.
does not exist.
No,
and how
yes, my
can
lord,
you-
I understand, my lord, if possible, my lord, protection.
Your
my lord.
petition is not there.
Yes, yes.
Then
Obliged, must oblige.
90.
Here, my lord, my petition, my lord, for praying for Jimma of Erekannath was, my lord, rejected. My lord. Impugn order, your lord.
Where is the order?
Page 45.
45.
Page 45. Page 45, my lord. Perusal of report submitted by IO revealed that the seized betel nut are required for further investigation. In view of the report so submitted, I do not deem it fit proper to hand over the Zimma of seized betel nut to the Zimma petitioner at this stage, madam.
Just tell us one thing, whether any FSL report is received by,
Lordship, my lord, official
Whether
report
those
was
were-
not called for, otherwise, my lord, so far, my lord, document I have annexed along with the, my lord, the petition, my lord.
showing your ownership.
Originality, my lord, page 43, my lord, observation of the learned court below is there, my lord. Page 43, kindly have a look. And my lord, so far edibility of my lord, betel nut is concerned, my lord, for considering a Zimma petition, my lord, that is also not required, my lord. Here division bench judgment is there, my lord, and today I am not, although my lord being that, my lord. But my lord, edibility, my lord, may not be a consideration for considering a Zimma petition. Our division bench judgment is there, my lord. Custom-
Considering a,
Considering a Zimma petition, my lord, edibility of my lord seized article is may not be considered, my lord.
That is there. If it
Custom-
is not fit for human consumption.
Then
also,
even then also, my lord, Zimma can be allowed, my lord.
That
no,
can be.
no,
allowed.
that can be.
Yes.
We are not on that. We are
Yes.
saying that whether there is any report.
Or report.
Because what is there?
So far,
As
my
per
lord,
SOP, you have to
Yes.
file a undertaking or indemnity where before the
that may be, my
court
lord.
below for the
Concerned as well.
for enquiry or the investigation whether your claim is genuine or not. That has to be there.
Yes.
Or so edible or non-edible is not a matter of, it can be, Jimma can be given. It's
And
not
page,
the,
page 43, my lord, here, my lord, it is reflected, my lord, so far, so far document I have submitted, all were was verified, my lord, and seen, my lord, or all were, my lord, found to be genuine, my lord. Page 43.
so your
last bit of it.
rejection is only on the basis of the report of the
Report, my
IO,
lord, report, my lord,
that it
for
may be required for further investigation.
further investigation.
Okay, we are calling for the first report, and then we also call for the FSL report, if any. So in the meantime, is there any, if the betel nut is sent for FSL or the food analyst report, if it is there, then it may also help you.
Then, my lord,
If it is still the existing quality of consumption, then it's okay. Otherwise, if it is already lost the quality of consumption, then it may not be fit for human consumption. That's what I'm saying.
then also, my lord, undertaking.
The undertaking,
Yes.
that undertaking, question of undertaking will come then.
Yes.
That's why we are calling for the, at present, report may be called for. Along with the presenter there as to whether there is any food analyst report, if any.
If any,
That
until then, my lord, my recommend maybe keep in safe custody, my lord. Otherwise, it will damage, my lord.
given
Keep in safe custody, my lord, because it's a perishable in nature, my lord. If it
as per you, whether it is safely kept or
till now it is okay, my lord, but after receipt of report, nobody knows, my lord.
home direction can be given now.
To whom direction?
Officer, my lord.
To whom?
They have, my lord, seized my articles, my lord, which were genuine, my lord. Now, if
Not
it
that
is
this that can
got
be
damaged,
done.
my lord, it will, my lord.
Mr. Cable, learned counsel for the petition. Also heard MSSH Bora, learned additional PP. Call for a report from the IO in regards to Jimma of the seized Erekanas, along with the report of the food analyst, if any. The investigating officer is also hereby asked to keep the Erekanas. No, and also requested to, also directed for safe custody of the Erekanas. Okay, sir. It will be listed after vacation.
So a date may be
Date
fixed, my
cannot
lord,
be
otherwise it's a articles, my lord, perishable in nature.
Immediately
got
after
damaged,
vacation,
my lord.
immediately after vacation, then definitely it may come before Bihu or immediately after Bihu. but we cannot fix any date.
Till then, my lord, this my lord safe custody, my lord.
Yes, I'll pass the order. Okay, already.
Obliged. Obliged.
After vacation also. After vacation.
After vacation, immediately after vacation, if it may come before Bihu also, we'll see.
Obliged.
20.
May I please, your lordship?
Yes.
My lord, my senior youngest counsel, another to and another attempt to another court. After some time, maybe take one.
You want to time me?
So much.
No, yeah, no, I can't. 21.
May I please?
21 is at 2 p.m.
My lord,
At 2 p.m. you prayed?
wait, but I did not go to.
Okay, okay, you can submit.
My lord, in this case, my lord, this is an application under section 528, my lord, for quashing of a CR case, my lord, initiated against the petitioner, my lord. My lord, translated copy of the complaint, my lord, started from page 16, my lord. The case of the complainant is that, my lord, the petitioner number 1 and 2 being the Lord Mondals, my lord. Latmandals. They surveyed the land of the complainant for acquisition for the purpose of construction of a road, my lords. But he was not issued for payment of compensation. In this regard, he filed a complaint before the deputy commissioner. Deputy commissioner did not take any action. Now he apprehends that the petitioner number 1 and 2 in collusion with the petitioner number 3 has withdrawn his compensation amount. This is his complaint, my lord. Your lordship, operative part, page 17, my lord. Complaint, my lord. May I read, my lord? Page 17. The complainant is an innocent tea garden laborer. In the year 2022-23, lands were acquired by the government for construction of new roads under Assam Mala. The road is going on the land of villagers of Sorashpur, Italkondi, Sand. Accused number 1 and 2 being Patwaris of LA branch have carried out the survey about the scheduled land of the complainant for the purpose of land acquisition. There is a fishery and agricultural land of the complainant on the said land. During the survey, the accused number 1 and 2 collected the ownership documents of land and assessed the value and compensation of land. Necessary notice were also issued in the name of landowners and beneficiaries. Although the notice were issued to the landowners, but as no notice was issued to the complainant, he on last 12/8/2024, along with
I mean, he did not get the compensation.
Now, my
so
lord,
you two are the Latmandals and 3 is the?
3 is the person, my lord, is the son of the person whom the compensation was paid, my lord. My lord, after his application.
Or the compensation which ought to have been received by the complainant, you have already misappropriated the the compensation amount or what? That is the allegation.
That is the allegation, my lord. Land is a harsh land, my lord. Your
whatever the compensation was there.
But it
that the poor person or the poor complainant, he did not get any compensation.
No, my lord. Circle officer acquired the land, my lord. Circle, kindly see the report.
Okay, then
page 30, my lord.
Don't have such time to see.
Page 30, my lord. Your lordship states serial number 34. Bula Prasad Rikeshan, this is the complainant. Serial number 34, my lord. Page 30.
30,
my lord. This is the report of the circle officer, my lord. Your lordship will find with remarks column. DAG number 44 not correct. However, during field verification, it is found that the DAG number would be 431, which is a LC hash and possessed by Ayub Ali. That is not by. There was a government hash land, my lord. Under Assam Mala project, my lord. Compensation was paid to the land was purchased, my lord, and compensation was paid to the person found in possession if it is a government hash land, my lord. After his application, land was a circle officer verified the area and found that he is not in possession. In possession, the petitioner Ayub Ali is in possession of the hash land, my lord. That is why fishery officer, my lord, your lordship.
That is the main issue. The land was in the name of, not in the name of, it is a khas land, in fact.
Yes, my lord.
So, but the position, you have shown the position to be other person.
This is the report.
And entire compensation was given to one family, which is who is not at all entitled, in fact. That is the case. That is the actual fact.
My lord,
case.
I am the.
Okay, then we are issuing notice. Notice is recorded.
And
to respond number 2.
one more thing, my lord, prosecution sanction is required, my lord. That is not available. Petitioner number 1 and 2 are the employees, and they only surveyed the area, surveyed the land. Nothing more than this, my lord.
What is the stage of the case at present? Cognizance has already been taken.
Taken, my lord. Notice has been issued, my lord.
Notice issue.
So further proceeding, my lord.
No stay will be there. Only
Notice should go.
notice should go. Notice to examine the video. Harsh and so video. We are listing. We'll try to list it immediately after beautification. That is, we call for the scanned copy of the LCR also, and it will be listed
29.
20.
29/1.
29. Your next date is fixed on when?
In the month, first week of February, my lord.
First week of February. No, before that also
Yes,
it can be
then
called for.
29.
Because yes, because
Yes.
29 is there.
Yes.
So it may be Aropan, it can
And
be all
27.
27 can. If it is there LCR, then automatically your thing will be there and one message will be there that petition is pending before this court.
And my lord, interim prayer on the next date. Consideration of interim.
No, I generally do not pass such kind of, I do not pass such kind of order.
Cannot be recorded.
It may be considered because if the LCR comes or the other petitioners appears also, or the respondent appears, it may be, the matter may be disposed of in fact, finally.
Yes.
So we are on which number? 21, no? List on 27/1. You take steps immediately today. We are calling for the LCR.
Obliged.
Application for quashing of FIR. The lordship will find the FIR at page 15. The vernacular portion, may I read the FIR? There are 3 accused persons. The FIR name accused person number 3 is before your lordship. She is the sister-in-law of the respondent number 2, the alleged victim, lordship. সন্মানপূৰ্বক বিনীত নিবেদন এই যে আজিৰ পৰা প্ৰায় 2 বছৰমান আগতে উপৰোক্ত 1 নং আসামীজনৰ লগত মোৰ সামাজিক ৰীতি নীতি মতে বিয়া হৈ আহিছো আৰু বৰ্তমান মোৰ 1 বছৰৰ এজনী কন্যা সন্তান আছে বিয়াৰ পিছৰে পৰা প্ৰায় সময়তে মোক যৌতুক বিচাৰি শাৰীৰিক মানসিক অশান্তি কৰি থাকে মোৰ বিয়াৰ সময়ত মোৰ দেউতাই মোৰ শহুৰ আৰু মোৰ স্বামীৰ একাউণ্টত 2,70,000 টকা যৌতুক হিচাপে দিছিল আৰু 1,30,000 টকা কেছ দিয়া হৈছিল সৰ্বমুঠ 4 লাখ টকা দিয়া হৈছে তাৰ উপৰি এখন আপাচি বাইক দিছিল মোৰ স্বামীক তথাপিও আসামীজন ও তাৰ পৰিয়ালৰ লোকজন সন্তুষ্ট নহল মোৰ দেউতাৰ পৰা আৰু যৌতুকৰ বাবদ 1.5 লাখ টকা দিবলগীয়া আছে বুলি দাবী কৰি মোক সদায় মাৰপিট কৰি থাকে যোৱা ইংৰাজী 23/10/2024 তাৰিখে সন্ধিয়া অনুমান 6টা মান বজাত বাকি থকা যৌতুকৰ টকাখিনি আনি দিয়াৰ বাবে উপৰোক্ত আসামীগণে মিলি মোক মাৰপিট কৰি আঘাতপ্ৰাপ্ত কৰে আৰু মোক প্ৰাণে হত্যাৰ ভাবুকি প্ৰদান কৰে The lordship, the petitioner before lordship is the sister-in-law of the respondent number 2. On perusal of the FIR lordship, what I found is that lordship, there is a delay. Firstly, there is a delay of 2 years for filing of this FIR. Because there are 2 sets of allegations. The first set of allegations says that 2,70,000 was given to the bank account of the husband as well as in the bank account of the father-in-law, and 1,30,000 was given in cash. There is absolutely no allegation that I demanded dowry and something was given to me. And that dowry was demanded at the time of marriage, and at that time, till 2/11/2024, there was no complaint or allegation has been made by the complainant lordship. And secondly, if your lordship peruses Jua Ingraji 23/2024 tarikhe. Now, my role is shown from here that I, along with these 2 other persons, assaulted the alleged victim for the demand of that 1,50,000, which I did not claim. The first set of allegations says that I did not make any demand of regarding dowry. And the second set of allegations says that I assaulted her along with 2 other persons for demand of dowry, which I never did. Which is clear from the perusal of the FIR lordship. Now, if your lordship peruses page 16 for a moment. Now, this is very interesting. The state of affair of our police lordship. Your lordship will find at page 16. The cases registered under section 84 of BNS. Now, 84 of BNS says that lordship taking or enticing away a married woman with an intent to having sexual intercourse with some other woman. No, lordship, as perusal of the FIR, there is absolutely no case against petitioner. Firstly, there is no case against petitioner number 3 against the present petitioner. Secondly, there is no specific allegation against the present petitioner.
Thirdly, there is no allegation that I demanded dowry. And fourthly, there is no case of section 84 BNS, Lordship. This is my case, Lordship.
So here, charge sheet has already been filed.
That information I do not have. That only public prosecutor can place it on record, Lordship.
But here, although he has stayed in different stages, my lord, in the FIR, my lord, I think it is read all over at a time, my lord. And if it is read from the first to end, my lord, our involvement is there, my lord. Lastly, on 23/10/2024, what happened in the incident, my lord, that is clearly reflected her also participation in the incident also, my lord. That's why Lordship may call for CD at this stage and also notice issued to the respondent. And in the meantime, Lordship may call for a record. After receiving the record, Lordship may pass the necessary order.
Record in a sense, it will
My lord,
be
CD, my lord.
CD.
CD, my lord.
Yes.
Thereafter, Lordship may consider their prayer, my lord.
But one thing we have to admit that on perusal of the FIR, Lordship, there is no case of section 84 of BNS.
That is, that's
Yes.
why read section 4 of the dowry prohibition.
Yes, that will not come against me because there is no allegation that I demanded dowry. The only allegation that the FIR number 1 and 2, they demanded dowry and something was given to them.
Lordship,
And in their
last
bank
part,
account.
last part, my lord.
Yes, last
Drawing
part.
gadget 7 তারিখে সন্ধিয়া 6 মান বজাত বাকি থকা যৌতুকৰ টকাখিনি আনি নিদিয়াৰ বাবে,
Which I never demanded.
that is demanded or not demanded, that is
The first part of the FIR says that I never.
উপরোক্ত আসামিগণে মারপিট কৰি আঘাতপ্ৰাপ্ত কৰে আৰু প্ৰাণে মাৰ ভাবুকি। That
Lordship
is
is-
sufficient, my lord.
Yes,
Lordship
yes.
may
Lordship
only-
is very well aware that the Supreme Court is deprecating practice of roping in the family members in such kind of vague and general allegation. This is absolutely a vague allegation. Your Lordship, if your Lordship peruses the
It will
first
be clear
set of
from the
allegations,
CD also.
if your Lordship peruses the first set of allegations, there is absolutely no allegation that I demanded dowry. And suddenly an allegation come against me that I assaulted the victim demanding dowry. No, the complainant herself is saying that I did not demand dowry. And now how can there be a allegation that I assaulted her for demand of dowry?
FIR is only, my lord, for information only, my lord. That's why thereafter investigation, police investigation is there.
This case is still in the investigation. You are on bail, I think.
Yeah.
Lordship, 41 a notice that was issued to me.
Otherwise, also we cannot stay in investigation at this stage. So we are issuing notice to the respondent number 2, and we are calling for the case diary.
Lordship. In the meantime, no course of action shall be
No,
taken,
no,
Lordship.
that is not here, my
At
lord.
least in respect of petitioner
No
number
court
3.
action is concept is not here. As per Supreme Court judgment.
No, Supreme Court judgment did not say that no course of action cannot be granted. It says that only a reason order has to be passed if your Lordship
Lordship,
grants no
court
course of
Like to
action.
pass any course.
My lord.
আর Mr. R. Bora করে দিব, B. Sharma. And this is an application লিখে দিব। Issue notice করে দেব না? For quashing of the FIR as well. Charge sheet is not yet filed. Quashing of FIR. Issue respondent number 2. And also call for the case diary. Case diary, for case diary, we need a date.
My lord. My lord. Pause. Heroni police station, my lord. This is
Heroni police station.
my lord. First week of January, my lord. Leave na? 23rd, my lord.
First week of January.
23rd January. 23rd January.
First week of January.
No, initially it was 23rd, my lord.
By that time, they will file the charge sheet against me. The date we.
Then you
Yes, so
can immediately file a additional affidavit for washing of the charge sheet also.
that-
Provision is there, my lord.
So because question is that prior being witness only 6, 7, 8, 9, 10, only 5 days are there.
Lordship.
3 is just opening day. So we already almost full, in fact, that's why. From the 11 to 28, it is 19 most probably is holiday.
Yes, sir, young, no?
Always.
Yes, sir.
23?
May I please, Lordship?
Yes.
Lordship, hearing the petitioner before this honorable court to quashing the infant proceeding pending before the learned CGM Hosai, Lordship. Hearing the petitioner number 1 is the accused number 1, Lordship, and petitioner number 2 is the informant, Lordship. Lordship, FIR page 17.
Accused number 1,
Is the FIR name accused number 1, Lordship?
petitioner.
Yes, Lordship. And petition number 2 is the informant, Lordship. Joint petition, Lordship.
Oh, it's a joint petition.
Yes, Lordship. FIR page 17, Lordship.
vernacular page 20. Informant Abdul Ali, hearing petition number 2, Lordship, and accused person Azharuddin, accused number 1, he is the petition number 1, Lordship, and against the petition number 2, Kopiluddin, no charge sheet has been filed, Lordship. May I read, Lordship?
For Kopiluddin, he has already been discharged.
Yes, Lordship. May I read, Lordship? সন্মানপূর্বক নিবেদন মিলিত নিবেদন এই যে মহোদয়ক জনাও যে যোৱা নিশা 2টামান বজাত 1 নং আসামীজনে 2 নং আসামীজনৰ লগত মিলি মোৰ ছোৱালী মিছ ৰুজিনা বেগম বয়স 17 বছৰ মিছা প্লবন্দি পলুৱাই লৈ যায় 2 নং আসামীজনে যোৱা 9/9/2023 তাৰিখে মোৰ ঘৰত গৈ ছোৱালীজনীক 1 নং আসামীজনৰ লগত বিয়াৰ প্ৰস্তাৱ দিছিল যদিও ছোৱালীজনীৰ বয়স কম হোৱাৰ বাবে মই প্ৰস্তাৱ অগ্ৰাহ্য কৰিলো বৰ্তমান ছোৱালীজনীক ক'ত পলুৱাই ৰাখিছে কোনো সন্ধান পোৱা নাই Accordingly, Lordship, the affair was registered under section 363, Lordship. Subsequently, Lordship, case 22, Lordship, charge sheet, Lordship. Charge sheet, it was filed, Lordship, against the petition number 1, showing him as absconder, Lordship, and under section 366, Lordship. Subsequently, Lordship, the petition number 1 approached before this honorable court seeking clearest bail, Lordship, and this honorable court granted clearest bail to the petition number 1, Lordship. Now, relevant portion, Lordship, case 26, Lordship. That's Lordship. During investigation, place of occurrence was visited. A rough sketch of place of occurrence drawn and examined. The informant was as well as the witnesses and recorded their statement under section 161 CRPC in connection with the case. The minor victim girl, namely Ruzina Begum, is so-and-so, daughter of so-and-so, was recovered and she was medically examined, Lordship. Below line, Lordship, medical examination of the minor victim, namely Ruzina Begum, was collected. In medical report, Dr. So-and-so, there is no evidence of recent so-and-so, Lordship. Lordship, nothing was happened, Lordship. The out of love affair, Lordship, they allowed, Lordship, and the petition number 1 kept the girl in the house of his relative, Lordship. Subsequently, after 1 day, she was handed over to the informant, Lordship. Now, Lordship, immediately after filing the affair, Lordship, there was a meeting, Lordship, village Bisar, Lordship, case 30, and the dispute was, Lordship, settled, Lordship, and the informant, both the party decided to solemnize their marriage, Lordship, solemnize the marriage of the victim girl with the petition number 1, Lordship, on attaining the age of her majority, Lordship. Lordship, on 7/2/2025, Lordship, the girl will attain the age of 18 years, Lordship, and subsequently, immediately after attaining her age, Lordship, they will solemnize their marriage, Lordship. The petitioner are before this honorable court, Lordship. So first was case 30 is the compromise state, Lordship. Now, Lordship, I am relying on the judgment, Lordship.
Yes, Sharma.
My lord, after investigation, police has submitted charge sheet in this case, my lord. In the charge sheet, it is already read out, my lord. Her age, according to radiologist, is between 14 to 15 years, my lord.
No, Lordship. Page 22, Lordship. Charge sheet,
I am
Lordship.
reading in page 26, my lord.
Yes, page 22, Lordship. The birth certificate already fixed by the police, Lordship, page 22. Property description table, Lordship. Page 22, Lordship. Property description, original copy of school proof certificate of Ruzina Begum, date of birth 7/2/2017, Lordship.
17 or 2007?
2007.
2007, then also 15
Yes,
years.
Lordship. On
Then also 15
on
years
7
at that
to
time.
on 7/2/2025, she will attend the age of majority, Lordship, and immediately after attaining her age of majority, their marriage will be solemnized, Lordship.
But when the offense was committed, that was at that time 14 to 15 years. Suppose it is 17 years, then also
No, Lordship,
minor.
15 years at the time of.
Whatever maybe she is minor.
Yes.
She is minor at that time, at the time of the
I
committing
agree.
offense. Right, that is 1 point minor. Thereafter minor compromise regarding that minor such type of heinous offense, there is no chance of compromise minor.
Lordship, I am.
Heinous offense minor. And initially he committed the offense and thereafter said that this was due to misunderstanding or that after minor final compromise,
there-
that is.
there
But
is
it
no
is
such
not the
evidence.
law minor here. In the law minor, heinous offenses cannot be compromised or coerced minor. And one important thing is also the 164 statement. I have not found that 164 what she stated, man. That is also not
Record
here.
call for Lordship.
Notice me issue at this stage, Lordship may call for record. Yeah,
In the
Lordship may
first
dispose.
proceeding may be state Lordship. Yes. Yes, 28 Lordship, order sheet.
What kind of proceeding now? You are shown as an absconder. So
Lordship,
what proceeding to
this
see?
honorable court has been granted bail to me, Lordship.
Bail,
on
you have already
on
appeared.
on 12/12/2024, Lordship, bail has been granted, anticipatory bail, Lordship. I will
Then we
Lordship.
appeared before?
I will appear, Lordship.
No, no, you have already appeared before?
No, no. On
Then
12,
what is to state? And that's what I'm asking.
Lordship, I will appear immediately. On 12/12, this honorable court granted bail, Lordship.
Yes, you obtained anticipatory bail
Yes,
now at
yes.
present. The case is fixed on
On 8/5/2025, Lordship.
Suppose proceeding notice started, madam, not yet
Yes,
someone
28
issued, not
Lordship.
any other.
Yes,
means
28.
it is 8/5.
8/5, Lordship.
8/5.
Yes, Lordship. Yes, 28, Lordship. Order sheet.
Yes.
28.
In which place? Case is pending in which place?
Someone is
before CGM, Lordship. CGM Hosai, Lordship.
Huzai.
Yes. Any date may be fixed, Lordship, before 8/5, Lordship. Short date may be given in the Lordship, meantime, Lordship. Outcome will come. Till that, proceeding may be stayed, Lordship.
Stay money, what kind of stay? That's what I think. Nothing is there in
Minor.
for to stay.
Minor.
There's nothing in fact. So shown as an absconder, you obtain already bail, and the case is fixed on 8/5.
Minor.
So we call for the scan
Scan
copy of
copy,
the LCR along with the case diary
Minor.
at present.
Minor.
And notice is may not be required because the informant is already there. So it was just simply calling. And if the matter, I mean, was there any? I think there is no such can not appearance at all. It is 8/5, so we are fixing it immediate after BU vacation. We are
Yes, ma'am.
fixing a date. Date cannot be given. I think after vacation, no? After BU vacation. List after vacation. It's called for the scan copy of the LCR along with the case diary CD. So CD will reveal this 164 also. And by that time, we have also pleaded that matter has already been settled.
Yes, Lordship.
And whether the case is charge sheeted under which section, in fact?
366, Lordship.
Only 366.
Yes, Lordship.
POXO is not added yet.
No, Lordship. From medical report, it is clear, Lordship, nothing has been happened.
So POXO not added.
Yes.
Okay, we have to list. Listing after vacation, after BU.
Obliged.
May I please your lordship? Well, this petition has been filed, my lord, for passing of a complaint. My lord, this petitioner before your lordship, he is a, my lord, retired head of the department psychiatry of Guwahati Medical College Hospital. He is aged about 74 years now, my lord. Complaint lordship will find 16. I don't know, my lord, for what offense, my lord, he cognizance has been taken. Absolutely no material. He is a resident of Guwahati, my lord. Some land dispute between some person at Swalkusi, my lord. And this doctor has been entangled with two medical prescription, my lord, which was, my lord, prescribed to the complainant's brother and sister in the year, my lord, 2017 and 2018. But you will kindly come to the complaint, my lord, at page 16. I am, my lord, accused number 6 in this case. I am a resident of Bhoralumukh, my lord, near Guwahati.
So
And
you are the accused number?
I am accused number 6, ma'am.
6.
At page 60, Lordship will find.
Yes, yes.
Dr. my lord, H.F. Fukan, ex-professor of psychiatry, GMCH Guwahati, resident of Borolumu, Guwahati. Other persons, my lord, they are resident of Kolkusi. So, Lordship will kindly come to the complaint now, my lord. May I read it, my lord?
Yes.
Complainant is a permanent resident of so and so, and accused being a resident of the aforementioned locality, and I know them since many years. All are residing nearby to our place. That my father used to run some kind of business with them. That in the transaction of business, they are supposed to get some outstanding money from my father. That my father is having some amount in land in my mother, brother, and in the name of myself. That is some outstanding money they have to get from my father. They have an evil, greedy motive, want to grab and occupy our land with the help of each other. They forcefully tried to occupy our land and forcibly took the custody of electricity bill, and line connection is cut down by them as some of their land property boundary is near. Then, my lord, this third paragraph is important for my lord petitioner. That one day, with the help of each other, trespassed in our house, demolished our boundary, wall and shop by conspiracy, and caught us with rope, and have taken Dr. Hemens Fukan's house. So, he is the my lord petitioner. Hemen Fukan have made 2 medical prescriptions in my brother and sister name by collecting drug tablets which are very much intoxicated in nature. They used to blackmail my father. He is a my lord psychiatrist. He doesn't remember, my lord, in the year 2017 or 18, some my lord patients came to him, my lord, and he prescribed some medicine. But looking at the my lord, the annexed my lord, the prescription, he said that it is his prescription, my lord. As a doctor, my lord, he has prescribed some medicine. And it is stated that, my lord, he was caught by such rope and brought to my lord his house, my lord. So that is in Guwahati, my lord. So how come, my lord, cognizance can be taken against, my lord, this doctor, my lord?
So you prescribe some medicine?
I prescribed some medicine
as per allegation
to the complainant's brother and sister in the year 2017 and 18. And this complaint is of the year, my lord, 2022, my lord. Only, my lord, some, my lord, oblique purpose, my lord, malafidely, my lord, my name has been inserted in this, my lord, complaint, my lord.
Cognizance has already been taken.
Cognizance is already, appearance date was also there, my lord. The next is 7th, I think.
7/1.
7/1/2025. How, my lord, learned magistrate has taken cognizance for, my lord, these offences, my lord.
Cognizance is taken under section.
Under section, my lord, 323. Then, my lord, 441, I think, my lord. 341, my lord, wrongful restraint. Then, my lord, 448, house trespass. Then, my lord, 107, abatement. 1016, my lord, abatement for offence which is not committed, my lord. And then, my lord, 276, my lord, if it could be connected with me, my lord, sale of drug as different drug as preparation. How
that section you are affected.
How, my lord, this doctor will come, my lord? Here he has prescribed some medicine, my lord.
State is here.
State, I have made a party because IPC offences are there. Complainant.
Formal party, I think.
Yes. The state is a formal party.
Heard Mr. B.M. Chaudhary, the learned counsel for the petition. And also heard Mr. B. Sharma, the learned additional VP, appearing on behalf of state respondent number 1. This is an application, section so and so in connection with so and so. issue notice on respondent number 2.
Two,
No respondents, no formal notice is required to be served on respondent number 1. However, extra requisite copy may be served during the course of the day. Also call for the scanned copy of DLCF. Next paragraph, hearing the submission made by Mr. Chaudhary, the learned counsel for the petitioner. The further proceeding against the present petitioner only in respect of the present petitioner be stayed till next date of the stay. List accordingly after 4 weeks. It will be stayed for against him.
Only. I am obliged, Lordship.
25.
Please, your lordships. Lordships, previous bail application, lordship, the FIR is at page 13, lordship. Herein, the allegation is that some persons in a Bolero pickup was trying to carry some cosmetic items, lordship, towards Bangladesh. This is the allegation, Bangladesh border. And the case is registered under section 303 subsection 2, 317 subsection 2 of the BNS lordship. So this section indicates theft and receiving stolen property, these two sections. But the contents of the FIR does not attract this section lordship. There is no FIR to this effect that some goods or articles have been stolen by somebody from somewhere. There is nothing. They suspected that these cosmetics were carried to the Bangladesh border for the purpose of smuggling. And herein, I am the owner of the vehicle lordship, and I am the second owner. The first owner was in the item number 16 lordship for Kitsa. And from him, I have taken this vehicle on actually agreement. There is an agreement lordship that is page 15. On the basis of this agreement, I have taken this vehicle, and this is driven by the driver, who is the main accused here, Rajiv Hussain. And Rajiv Hussain is arrested lordship, and now the police is searching me, the present petitioner Shakwat Hussain. Shakwat Hussain is in no way involved in this case, lordship, because the driver was flying the vehicle as a commercial vehicle, Bolero pickup. So at this point, my submission is that some internal protection may be granted. I will appear before the IO lordship, and thereafter the case may be decided. I am the owner. This is admittedly I am the second owner. The driver has informed the police that I am the owner. Shakwat Hussain is the owner, and in reality, the registered owner is Fakir San, and the vehicle is yet to be transferred to my name. And I am running on the strength of this agreement lordship at page 15 lordship. And Shakwat Hussain has and Fakir San has also had a petition for the zimma lordship in item number 16. That was the answer.
Yes.
Internal protection is that.
Madam, here regarding the materials, my lord, here total amount is 13 lakhs.
That is including the vehicle lordship.
24,700.
That is
amount.
That is including the price of the vehicle lordship. The vehicle price is 8,85,000. That has been included along with this cosmetics lordship. Garnier, Mama Earth, Ponds, etc. These things. And these were carried by some other persons. The driver was only carrying them on hire. So I am not for the driver lordship, I am for the owner. I have no involvement in this. I shall appear before the IO.
I prefer CD, my lord.
Yes, CD may be called for.
It will be clear from CD
Yes,
whether he is knowingly or without his knowledge, it was given hire to the other person for carrying this type of materials, my lord. That is also Indo-Bangladesh border, my lord. That is also one thing.
But these sections are not attractive.
That is
Therefore, receiving stolen property, that is.
We don't need any thing, I mean,
lordship.
pass and all to cross the border. You can easily cross the border.
No, lordship. Actually, I'm the driver. The driver is my driver. He is my driver. This is my vehicle. The driver is behind the bus. I have nothing to say. I am the owner, Lordship. I know nothing about this.
You allow him to cross the border.
No, he comes to Guwahati and goes to Mankasar. I am from Mankasar, Lordship. The owner is from Mankasar. And
To
Mankasar
cross
is
the
the border.
border, nothing is required.
No, Lordship, he did not cross it. He did not
Not
cross.
to
There is
cross
no
the border.
allegation. No, Lordship, there is no allegation that my vehicle crossed the border.
The
They
entire
suspected.
truck was loaded with the cosmetics. Then what purpose you were going there?
No, this is Bolero vehicle. This was going from Guwahati to Mankasar area. My vehicle comes to Guwahati with the goods and goes back to Mankasar. And in the meanwhile, some person actually boarded my vehicle on hire. They were carrying all these things. They fled away. Leaving all these articles, they fled away, suddenly finding the police. And my vehicle has been seized and the driver has been arrested. And now police is searching me. This is the fact, Lordship. I am not saying that the driver is innocent. He might have done something. But that is without my knowledge. This is commercial vehicle, Lordship. This is not private vehicle. Bolero pickup. So at
You are
this
Mr.
Jad Hussain.
Heard Mr. Jad Hussain, Reliant Counsel for the petition. And also heard Mr. B. Sharma, Reliant Additional VP, appearing on behalf of so and so. It's an application on section so and so in connection with so and so. It is submitted by Mr. Hussain that the present accused petitioner is innocent and he is no way connected in the arrest offense. It is the fact that he was running the vehicle as it was on the basis of the agreement with the registered owner, namely one Fakir Chand, but the ownership is not yet transferred to him in his name. However, he was running the vehicle on the basis of a said agreement. I repeat over and we won't do anything. But he was not aware about the fact that the cosmetics were loaded in his vehicle, or it was tried to cross the India-Bangladesh border. However, he is ready and willing for your interim for you. Okay, you'll be under interim protection.
Deeply obliged.
Within 7 days, you appear before the IU and insisted for case diary to put it. CD can be fixed at
29th January.
29 months.
Obliged.
26.
In this matter, there's a connected bail application, regular bail application, which is fixed in court number 3 today, my lord. And case diary is also available. So may I know, my lord, because case diary is available, it is likely to be disposed of. Then this matter will have to be decided by court number. If your lordship is kind enough to fix it tomorrow before appropriate bench, my lord.
Before appropriate bench.
Appropriate bench, my lord. In the sense, because if it is disposed of today, CD is available, it can be decided tomorrow.
Out of same FIR.
Same FIR.
Submission to deem কি করবে?
We'll give that case number.
Appropriate bench করবে।
That item number 27.
No, you are on 26.
26, no, that is 27 in court number.
Achha. Item number 27, he is saying in court number 3. This before appropriate bench. Tomorrow is the demanded. This is it. Okay.
Deeply.
Only request for you.
27.
May it please your lordship.
Yes.
Lordship, this is anticipatory bail application, lordship. FIR with page number 15, lordship. May I read the FIR, lordship?
1-5.
Yes, lordship, 1. I am to inform you that my auntie, Mrs. Jahana Begum Borjina of Silchar, Assam, is having 2 PAN cards in her name. Accordingly, in the month of July 2024, I, along with my auntie, went to the office of Income Tax Department in Silchar, Assam, where we met Sri Sudarshan Das, Income Tax Assessing Officer, and told him about the sale. He directed us to submit an application. Accordingly, we submitted an application for surrendering 1 PAN card bearing number so-and-so, where we met Srimati Simi, Sri Sapon, and 1 lady whose name is not known to me. In the meantime, Sri Sapon told us to pay an amount of rupees 10,000 as bride for the said work. But I refused to pay the bribe. That 3-4 days back in the month of November, I revisited the office to follow up the matter. When I met Srimati Simi and the lady, that lady asked me to pay the bribe and told me that if I don't pay the bribe, then the work will remain pending. Since I want to close or surrender the above PAN card, I told them that I will pay the money when our work will be done. However, that lady told me that I have to pay her at least rupees 2,000 as part payment on that day itself. Accordingly, left with no option, I paid rupees 2,000 to that lady on that day. In the meantime, she told me come on Monday, that is 25/11/2024, for payment of another rupees 2,000 as another part payment. However, as I am not willing to pay the bribe, I approach CBI for legal action in this regard. In view of the above, I request you to take necessary legal action as per law. Lordship, the petitioner's name is not there in the FIR, Lordship, and she is no way connected with the LS Commission of Affairs. But she is apprehending arrest because there is repeated communication from the investigating agency to appear before them in connection with the investigation of the matter, Lordship. So she has approached before this honorable court to protect her, Lordship.
No, she is that lady, I think.
It's not there. It is not.
No, not there,
identified
not
as
there
the-
because she was not known to her, in fact.
No, Lordship, fact is that actually they should have withdrawn this petition because she is a witness. Therefore, she has been called. She is a witness to this case.
Oh,
She has been called as a
no,
witness.
that lady, she is that lady or
No,
no?
no.
Oh, acha, acha.
So they should withdraw this petition actually, and the petition should not be entertained. Because
Okay.
a witness, Lordship, where is the apprehension, Lordship? Where is her apprehension?
Because she is
has been called as a,
that office.
she has been called as a witness, as per my instruction from the IO, Lordship.
Okay.
So such petition should not be filed before the High Court, Lordship. Very sorry to Lordship say these things, Lordship.
That may be the position, in fact, actual fact may be there, but because the Mr. Hallow has the instruction from the IO, in fact. So you are calling as only as a witness.
She didn't know that she is a service holder in that office, Lordship. So she is apprehending that she may get arrested in connection with the matter, whereas she is no way connected with all that.
Why she is apprehending? No accusation in the FIR. Why she is apprehending? Only because I always called her. Can that be a ground, Lordship? Let the then CD be called for, Lordship, in the next day, Lordship. I'll produce the CD and
Otherwise, he is suggesting you that you can withdraw and you can appear because as a witness only, I don't know, maybe
Yes, yes.
from the
Lordship, after that.
CD. Okay.
In the meantime, Lordship, she may be protected.
no, Lordship. Why
No.
should she be
No protection will be there.
Why you want?
You are calling as a witness only. No protection will be there. CDB call. By that time, you can make an inquiry with the other officials. If you are simply calling as a witness, then no issue. Appear before the last time. That's all. For that reason, because there is nothing against you and the council, Mr. Hallow is submitting that only as a witness you are calling.
Lordship,
So we
that
cannot
may
give
be
any
reflected
protection.
in the order, Lordship. That she has been called as witness, Lordship.
No,
That may be
that's-
reflected.
Let the CD come.
Then
we'll
let the CD
reject
come.
the bail application. Okay. And then we'll arrest.
CD can be called for, yes, Hallow,
Vacation, Lordship. Let it be after due vacation.
after vacation. As per notice, when you are asked to appear,
Lordship, it is not communicated with us. That
you have the
exact
notice
date-
with us. No.
The exact date we don't know, Lordship, when she is to appear.
Okay, then you pray for one date. If it is, before we are going to fix it after vacation. If it comes within that, then you pray for a time for appearance. That will be allowed by the investigating officer. That will be easier for you. 21 month reading. 24. We are listing it on 24.
Okay.
Okay.
May I please, Your Lordship?
Yes.
Lordship, this is the PRS bail applications in connection with the KTPS case number 193, 24 and registered under section 127, 2, 75, 1 and 2 of BNS, read with section 8 of the POCSO Act, Lordship. So, Lordship, the FIR is at page 14. Your lordships, from the plain reading of the affair, only one allegation is that the petitioner has placed his hands on her face. That is the allegations in the entire affair, because
in Muhammad Azmal Muhammad Amir Kasab, this court relied on Khatri and held in paragraph 474 of the report as follows. It is the duty and obligation of the magistrate before whom a person accused of committing a cognizable offense is first produced to make him fully aware that it is his right to consult and be defended by a legal practitioner. And in case he has no means to engage a lawyer of his choice, that one would be provided to him from legal aid at the expense of state. The right flows from Article 21 and 22(1) of the Constitution and needs to be strictly enforced. We accordingly direct all the magistrates in the country to faithfully discharge the aforesaid duty and obligation, and further make it clear that any failure to fully discharge the duty would amount to dereliction in duty and would make the magistrate concerned liable to departmental proceeding. Now, paragraph 44, this is important. Strong words indeed. That being so, we are of the clear opinion that adopting this principle, it would equally be duty and responsibility of a court on coming to know that the accused person before it is entitled to default bail to at least apprise him or her of the indefensible right. A contrary view would diminish the respect for personal liberty, on which so much emphasis has been laid by this court, as is evidenced by the decision mentioned above, and also adverted in the Nirala Yadav. And this similar view expressed in the other judgment which I have given, Lordship, flag mark I have given, Lordship, that paragraph 12.7. Three judges done decision, Lordship, this is.
Yes.
We agree with the view expressed in Rakesh Kumar Pal Supra that as a cautionary measure, the counsel for the accused as well as the magistrate ought to inform the accused of the availability of the indefeasible right under section 167(2) once it accrues to him without any delay. This is especially where the accused is from an unprivileged section of society and is unlikely to have access to information about his legal rights. Such knowledge sharing by magistrate will thwart any dilatory tactics by the prosecution and also ensure that the obligations spelled out under Article 21 of the Constitution and the statement of object and reasons of the CRPC are upheld. So here as per my instruction also, he is represented by a legal aid counsel in the district court. But that information was not provided to him. That co-accused was granted default bail and he is also entitled to default bail.
For that reason, we'll have to go to the scan copy matter. At this stage, Lordship may call for scan copy matter to verify the facts and circumstances.
It is already there. Forwarding report says when he was forwarded and default bail orders and his production I have annexed in with the petition.
But for final decision of the case matter, it is necessary to go through the record also matter. With the record matter, it is difficult for us also matter to argue the matter.
Because it is default bail.
Whatever may be matter.
No, in default bail, merit or other things does not come. Here only the date of arrest and when that right to default bail accused. That is
Only matter is to be seen most probably from their side. It has to be that as you have submitted a legal aid counsel was appointed. Whether was there anything because default bail unlawfully here. But obviously you have submitted that that information was not with him regarding that he is entitled to default bail. Okay, then let us call for the scan copy of the record along with the case. No, case diary will be there only.
So the date when he was immediately after that on 4/11, 4/1 he
Now
was
case is
produced.
at the stage of evidence, or what is the stage?
Charges are framed, Lordship.
Charges are already.
Along with all the orders of this court, man. Court below, man.
No,
Order
if
sheets.
scan copy is called for, then we will come.
All the order sheets, it is necessary.
Particular date, as Mr. Ahmed has submitted that the co-accused was also represented by any legal aid counsel, or he was engaged counsel?
He has engaged counsel.
Engaged counsel.
But co-accused bail was granted on 28/12/2023, 1 year back.
No, he is on that only.
Informed he was.
That
He
is
was
their
never
personally call for the record, along with orders.
I mean, it's Ahmed's principle is that the co-accused was not informed
Right.
regarding his entitlement. That is. But one thing is there, your petitioner was arrested subsequently.
No, on the same day.
Same day.
Same day.
Same forwarding.
Same forwarding, Lordship. That is why I have placed that.
Yes, you have already placed.
Yes. On the same day they were forwarded.
When it can be called for, the petitioner is behind the bar for when, since when now he is in?
28/9/2022, 1 year, 2 months,
1 year, 2 months.
22 days.
See to it. Scan copy of the.
POCSO is also here.
Yes,
POCSO
six POCSO is there.
POCSO 6 is there. Then if POCSO is there, then perhaps notice regarding.
Oh,
this
yes,
matter.
yes, notice has to go.
For default bail, probably whether it is.
No, any kind of
Any
bail, any
kind
kind
of
of bail at
hearing,
any stage, the
any-
order says so.
In my
Any kind of bail, at
Hearing.
any stage can be. Presenter das. You should notice for it and also call for the scan copy of the LCM with the present status report of the case. So
Okay.
Ahmed, it will be
Notice.
obviously after Bihu vacation. We don't have any dates, in fact, prior Bihu. Prior Bihu, we don't have any, only 6, 7, 8, 9, 10 is open day. She just informed me that already 15, 16 matters have already been fixed there. That is
Immediately after
so immediately after Bihu vacation will be date.
On
Because
20
notice is also going.
My
It
lab,
takes
okay.
it within by
But
tomorrow or by
by
day after
by-
tomorrow.
By
within-
tomorrow, Lordship, I will take through PP office.
That process, yes.
That process.
Through jurisdiction police
yes.
station routed to the office of the registry and the public prosecutor. In that process,
Some 21 or 20, Lordship, very late.
20 is almost full.
21 or
23rd, 24th. 24th. She is suggesting 24th.
Outline.
May I
So,
please,
like,
your lordship?
fear.
May I please, your lordship?
How are you? Take care.
May I please, yours? And for item number 31, my lord. My lord, the scan copy has been received, but it has not been up to date, my lord. The last it was on 11/11. So after the case, the scan copy may be called for, my lord.
Okay, sit.
Of that, 31.
Yes.
Yes, please.
Yes.
Just speak for instructions.
Oh, acha, yes.
This case, my investigation is pending, madam.
That's not submitted.
So morning hours, usually you were submitting that it is already 47 days. No, isn't it?
Yes, yes.
They have time, my lord, 2 weeks time, sir, they have to complete the investigation.
Then when to fix this, just tell us.
Hard one.
That will be statutory period will be over, I think.
Default bail before a trial court, my lord.
Yes, obviously.
Lordship, this involvement is, what is this involvement, Lordship? He may be harboring offender, Lordship, but not in NDPS. Because he helped the accused as per allegation. That is the offense. So on that ground, Lordship, cannot be.
Just the case diary, my lord. That is
No, no, as per forwarding is there, after receiving the case, there is trial court rejected this period, recorded the city. Only involved is the health sector. It's reflected. So consider direction may be considered loss.
If you get my lord on my lord, suppose on 21st you will complete my lord, or 22nd you will complete 60 days, my lord. Then the matter would have been different, my lord. Still there are 2 weeks time.
Obviously, but from as he submitted from the FIR as well as for forwarding, he was helping only to escape the. But the question is, this 29 is I don't find here. Is there any 29?
No, no loss.
29 is not there, my lord.
Only 20. Specific allegation against the two acres, not the present. It reflected the FIR also.
Mr. J.
29 is not there.
You're Mr. J. Ahmed.
Yes, Lordship.
Heard Mr. J. Ahmed, the learned counsel for the petition. And also heard Mr. R.J. Borwa, the learned additional PP, appearing on behalf of state respondent. And this is an application under section so and so, connection with so and so. It is submitted by Mr. Ahmed that the present accused petitioner is innocent and he is no way connected in the alleged offense. The only allegation brought against the present petitioner in the FIR as well as the forwarding that he helped the other 4 accused persons to fled away from the incident. Fled away from the incident. That apart, there is no other allegation of any recovery or other recovery or other allegations to show his involvement in the alleged offense first. More so, the accused petitioner is behind the bar since last 2/11.
3/11.
2024. And thus the IO got sufficient time for her custody interrogation as the accused is behind the bar since last 47 days. Accordingly, further he submitted that the petitioner will extend and the accused petitioner will extend his cooperation in further investigation of this case if he released on bail. Next, Mr. Borwa, the learned additional people submitted in this regard that on inquiry made by him, the investigation is still under process. And he further submitted that his involvement of the present accused petitioner cannot be said at this stage as and which may reveal only after perusal of the case diary. Accordingly, Mr. Borwa insisted for calling for the case diary. Next, hearing the submission made by learned counsel for both sides, I have also perused the case record and the annexures filed along with the petition. And it is seen that the main allegation brought the allegation brought against the present accused petitioner is only to the extent that he helped the other co-accused in fled away from the place of incidents. That apart, there is no other allegation of any commission of the present commission of offense in this case. However, during the investigation, there may be some involvement. However, during investigation, IO may find some involvement of the present accused petitioner. Leaving apart the merit of the case, it is also seen that IO got sufficient opportunity to interrogate the accused petitioner, keeping him in custody. And considering all these aspects of the case, I find that further custodial detention may not be required for the interest of the investigation. And accordingly, I find it difficult to extend the privilege of bail to the present accused petitioner. So and so, whose satisfaction is there?
Nalbari, still just Nalbari.
Session Judge Nalbari.
Special Judge.
Special Judge Nalbari. 50,000 with true surety of like amount to the satisfaction of Special Judge Nalbari. Okay.
Hand of blessings.
20. 20. 20 key Mr.
You have a limited prayer. NBW is issued against the petitioner before a lot. So Lord, we are praying that that may be set aside. And you are earlier previous bail. So now he is ready to surrender before the learned trial court. So we are praying that NBW may be set aside. So far it relates to the petitioner before a lot.
Since when NBW is the first date of issuance
First
of
date,
NBW?
1/2/2019.
Since then NBW is there.
Yes.
Then
Now a proclamation era. Proclamation is.
then 2019 NBW is there. Proclamation is also there. Then how can you say it's a simple case?
Now, page 38, there is the issue NBWs and proclamation against accused Jonavati, Ali Hussain and Jamir Ali. Yes, madam. Proclamation is there now.
So since 2019 you are sounding. Then what?
That is that.
See the question.
Now he is ready to surrender before the court. So
now he will be ready. Your petitioner's name is?
Jamir Ali, madam.
Yes, Burwani, sir.
When the PNA is issued, my lord, then my lord, is not a question of my lord granting him any privilege of my lord, any protection, my lord. When trial court has rightly passed this order, my lord. Let him appear, my lord, no protection, my lord. Let him appear within 15 days time, my lord. And trial court will pass necessary order, only the appear.
Item number 20. No? Yeah, Mr. K. Raman.
K. Raman.
Heard Mr. K. Raman, the learned counsel for the petition. And also heard Mr. R.J. Borwa, the learned additional PP, appearing on behalf of said respondent. This is an application. You are all subsequent orders or you are
subsequent orders? Well, so far it relates to the
10 your 1 to 2000
1 to 2019 onwards.
1 to 2019 onwards. No?
Yes.
Pay for setting aside and quashing of the order dated 1 to 2019 and other subsequent orders whereby NBWA and PNA was issued against the present petitioner. It is submitted by it is submitted by Mr. Rahman that the present accused petitioner was on previous on bail and his prayer for previous bail was also allowed by the learned trial court below. And in various occasions, he was also represented by his engaged counsel. Why you could not appear?
But he was left for searching work in different
places.
Yes.
But since 2019, as to earn his livelihood, he had to live different. He had to go different places in search of his livelihood, and for which reason he could not appear before the learned trial court below, and his engaged counsel also did not represent him. However, he is at present he is ready and willing to appear before the learned court below, and if learned court below, and to contest the case, appearing each and every date to be fixed by the court. He further submitted that till he appears before the learned trial court below, he may be protected by suspending the NBWA issued against him. Next paragraph. Mr. Borwa, the learned additional PP, submitted in this regard that that the accused petitioner was remained absent since 1/2/2019, since when the NBW was issued against him, and in spite of several steps taken by the learned trial court below, his attendance could not be procured, and for which PNA had to be issued against the present petitioner. Full stop. Thus, there is no illegality committed by the learned trial court below in issuing the NBWA as well as PNA against the present petition. However, and as the case PNA has already been issued against the present petitioner, there cannot be any there may not be any there cannot be any interim protection to the accused petitioner. However, he may be directed to appear before the learned trial court below with an appropriate application for bail. Stop. Next para. Hearing the submission made by learned counsel for both sides, I have also produced the case record, and it is seen that prior to 1/2/2019, the accused petitioner was on previous bail, and in several occasions he was also represented by his engaged counsel. But since 1/2/2019, that is 1982, since almost 6 years, the accused petitioner is absconding and avoiding the police arrest. And even after several efforts made by the learned trial court below, his attendance could not be procured, and for which the trial court had no other option but to issue PNA against the present petitioner. Thus, considering the conduct of the accused and the effort of the endeavor made by the learned court below to procure his attendance, I find that it is not a case wherein any interim protection can be given, can be extended to the accused petitioner. Full stop. However, the accused petitioner is hereby directed to appear before the learned trial court below with an appropriate application for bail, which may be considered in accordance with law, considering all pros and cons of the case. With the above observation, the instance disposed. He is not a case for interim protection. You appear before, but it's to the sake.
NBW may be state, my lord.
No interim protection. And we are not giving any interim protection to you. Appear. For the last 6 years, he had to.
That is true, my lord.
Yes. Okay. This is disposed of.
For the hearing item 30.
3-0.
My lord, this petition is pending more than a month, my lord. On 2 occasions. In 1 occasion, they have produced the CD, but it was not up to date. They have also, my lord, sought time to, my lord, produce the FSL report and CDR. But what I have now find, my lord, the CD has not come. By today, my lord, I have been completed more than 141 days. Now, this so far as the allegation in the FIR is concerned, my lord, it was one Abdul Jalil in whose premises the alleged drugs were found by the police. And that particular Abdul Jalil in whose residence these drugs were found, he said that he has a family dispute with the his brother, that is me. We are the brothers. So I have planted the this particular drugs in his house. So therefore, Abdul Jalil was left loose. He has not been arrested, nothing, and I have been put behind the bar. So
But the contraband was recovered from Abdul Jalil, house of Abdul Jalil.
Yes. It is in the FIR itself. Now he said, because of the family dispute, I being the brother, I have planted that, and therefore, he was never taken into custody. I have been put behind the bar. That is the case, and the contraband, whatever they are saying, is I find that it is also not covered by the tables. Certain cough syrup and some tablets were found. The table I did not find as such, these 2 products. There may be the ingredients may be there, but then exactly product is not mentioned here. More than 141 days and the admittedly it was not my position. 22C request specific the position. And the apex court also in the recent Palubail case specifically said the co-accused or the confession, etc. If the position is not found, that will not consider. At the time of arrest, what was the material before then? Absolutely.
Yes,
from the
Burwa,
FIR
what is
itself,
what is the position? Today also you have not received the case diary?
When not received the case diary, my lord, and this is the intimation we have been forwarded, my lord. That case diary is lying before the landed session court, my lord. It was not returned from the landed session court.
Session court, which session court?
My lord, Sonitpur, my lord, probably. No, it's not Sonitpur, my lord, Nogam, my lord.
They have a right to defend the arrest, but not buying time by producing the CD. More than a month is here. I am behind the by
report, my lord.
141. That may be a report, but they should have that the police officer should have been diligent to produce the this case diary to defend the arrest. Now, admittedly, in the FIR, Lordship will find it was never found in my position. FIR Lordship may kindly have a look.
Oh, yes, so I can understand, but the question is the position was not there, I think,
No.
as per FIR, but the
Lordship.
it's a commercial quantity. How can you pass the order without
The
perusal of the
drug
case
itself
diary?
is not civil drugs as per the table, my lord. What I find.
Yes, Burwa, what can be
They can
done?
produce the scan copy by tomorrow. They can do it scan copy only. They
Not
can
possible, my lord. It is, my lord, case diary is lying before the session court, my lord. So as per the report, my lord, that I'll place the
Since when it is lying before the session court?
my lord, on 7/12, my lord.
Am I at
7/12.
Yes.
The first that CD
But
was
everything
here.
is report, but receive case diary along with the FSL report, everything is received, my lord. It is lying before the landed session court, my lord, and session court has not returned the case diary. My lord, today they could not produce the case diary, my lord.
Paying for a scan copy, my lord. That public prosecutor, the police inspector can easily, my lord, have a scan copy and send the document to you.
Scan copy, my lord, when it is searched, it is submitted, my lord, that it can be called for, my lord. But from the case diary, my lord, it is difficult to my lord, call for a scan copy. My lord.
And
That
who
is
will
also
prepare
by-
the scan copy for you? Because it is lying in the
Yes,
case
ma'am,
court
that
of
is
law
right.
also. We cannot direct the court at present to prepare or obtain a scan copy.
No, I have calculated, my lord, today is 141 days, my lord. So let it come immediately after vacation, my lord. Maybe a month day of reappointing, my lord.
On third.
On 6, my lord, 6 or 7.
6th.
No. My lord, I would pray, my lord, if this CD is not produced, at least without this CD, my case be considered, my lord.
That you submitted, I have heard, but
Right.
cannot be. It's a commercial quantity case. It should not be in fact.
No, my lord, the drug itself is not civil drugs, my lord. They have to prove that it is as per the table, my lord, it's a contraband, my lord, that's such.
Initially, my lord, CD was received. It was sent back, my lord, along with the FSL report, my lord. And
Why it was
after that-
sent back?
Because my FSL report was not received, my lord.
Oh,
That is why.
FSL was not
That
there.
is why, my. I had ordered it at 28/11, my lord, it was sent back, my lord.
Fixed on 7th in that case, my lord, 5/7.
7th. Mr. P.J. Sakya, the learned senior advocate, assisted by Mr. M. Alam, the learned counsel for the petition. And also heard Mr. R.J. Burwa, the learned additional PP Swens. It is submitted by Mr. Burwa that the IO has intimated that CD could not be sent as same is still lying before the Court of Learned Session Judge Sonitpur or
No, my lord.
the Session Judge Nogam. To stop. In that context, Mr. Sakya, the learned senior advocate, submitted that the present bail application is pending since
For the month of
since
November.
13/11/2024, and till that this CD along with the FSL could not be produced by the prosecution. Mr. Sakya further submitted that the case is a false and concocted allegations brought against the present petitioner only due to some family grudge or dispute. Next paragraph. In view of this, the Mr. Bordello, the Borba, the learned additional PP is hereby asked to take all necessary steps and to intimate the IO to obtain the case diary, which is pending, which is lying in the court of learned session just Nagaon, and produce the same honor before strict honor before next date of listing without fail. List the matter accordingly on, you are insisting on 7th? 7/1/2020. Try to get it because obviously he is in custody and that apart, other information, the recovery was also not from his position, whatever. Later on it may become or whatever, and the list or annex you also go through as per him, it may not be any, it may not be, then the jurisdiction of any synthetic drug and all. So if it is there, if it's not in the table, then it may be one of the aspect also.
Okay.
52.
31 to P1.
May I please allow?
Oh, it one. It was a publication there. They delayed no কোনো পইছো পাবি তো মই লিপাকে কইছে না জানি মই ইকালে ভাবা না আপনি লিপাকে কই দিছেন আপডেটেড তোর কারণে no I know but কোনটো নাম্বার আসলে মই মনত নাই 32
May I please, sir?
Yes.
Because the petitioners are Sapera Manda.
Sapera?
Sapera.
Huh.
Look, offense report at 80 law.
What is representing what?
Lordship, I'm appealing for special PP wildlife lordship.
Page is that?
Page 8, my lord.
Page 8.
Page 9, my lord. Read details of the offense. On 15/11 so at about so information was received at Ryan's headquarters regarding display of wild animals and wild articles at Langla market area of Bangagar district. Accordingly, a team was constituted immediately comprising of staffs of Overpuri Ryan's, and I was made the team leader to lead the operation and rescue the wild animals from the culprits. I along with the
written as wild animals, not only snake, that means.
Snakes, my lord. Only snakes, my lord.
Oh, acha, Indian spectacle cobra.
I along with the staffs of Overpuri
3 numbers of Indian
Red
red
snake,
snakes.
yes.
Wow.
Yes, my lord.
Hornet flying snakes.
And one
All
number
are
of
very, I mean, these species, these are
Yes,
all.
these are schedule ones.
They're Sapera, my lord.
No, Sapira, but how,
Yes.
what kind of thing, I mean,
My lord, kindly peruse paragraph 2 of my petition.
these are all actually about to be
Yes, my lord.
extinct. In fact, these are all
That
endangered.
is
Yes.
protected reptiles, my lord.
Yes,
That is admitted fact, my lord. My lord,
because the
they-
red snakes and the hornet
they
flying
didn't-
snakes, these are very.
They didn't know.
So
about-
how we obtain all these things?
We're
If
Sapera-
Sapera, you may have a.
Our forefathers were also Sapera. Sapera.
Cobra and all may be there, but the see the hearing.
My lord,
Since when you are in custody?
From
15/11.
16/11.
16/11.
15/11/2024. My lord, further custodial interrogation is not.
Yes,
required,
what
my
you're
lord.
saying.
Lordship, the record has come, but I have perused the record, except that the order passed by the learned SDCM, there is nothing on record. The preliminary offense report is there only. So.
You have not received any?
No, in fact, no copy has been served to us also.
Yes.
Special PP because DP Goswami appeared on last occasion, so special PP wildlife did not receive any copy. So if your lordship fix this matter tomorrow, I can place the instruction as to whether.
They're not going to fix any.
Or on
Tomorrow.
3rd of January, because.
No, my lord, they are all.
Except the ground that they are poor person, there is no ground for.
My
Yes,
lord,
lordship.
kindly have a look at paragraph 2 of my petition. my lord.
No, we don't have much time. We're rising by 3,
It
in
is
fact.
admitted fact, my lord. All the cobras have been recovered from our possession, my lord.
Yes.
Merely because of our ignorance, my lord. We are Sapera. We did not.
But while interrogating by the officer, you have said that you have the license.
No, my lord.
We do not have any license, ma'am.
But as a brief note, he's saying that you have license.
No, my lord.
What they are saying before the investigating officer is that, Lordship, they do not have the legal knowledge of.
Which they
keeping this-
replied that they do not have any legal documents. Acha.
Yes, my lord.
Yes.
We are illiterate.
Only you
persons,
can say whether further custody interrogation will be necessary required
Yes,
or
ma'am.
not. That much only.
Lordship, the difficulty is that these people, they are snake choppers. So they are, they procured it from somewhere. So we need to investigate that aspect also. So that what we are trying to find out is that what is the nexus between those who originally recovered those snakes from the jungle and given to them. So we are trying to find out that aspect.
My lord.
And in other cases also, what we have seen is that some people from Mizoram and Myanmar are also involved in these kind of offences. So therefore, your lordship may fix it on 3rd of January. By that time, I will produce the relevant records also, and their statements are
My lord.
also there.
We used to show magic in
So
open
today you
market,
have not
man.
received any.
Market.
No, nothing, lordship. The record is your lordship, with your lordship.
All the snacks have been recovered from open
second-
market, my lord.
The second
We are
part.
showing magic, my lord, in open market, my lord. We did not conceal the snacks, my lord.
Huh?
We did not conceal the snacks, my lord.
How can you conceal? It is already recovered from your position.
My lord, we are,
If there would have
we are
been any
magician.
time would have been provided to you, then
We
definitely.
are
you would have-
sapera, my lord. We are
Sapera, I can
sapera,
understand.
magician, my lord.
In our childhood also we have saw
Yes,
the
yes.
sapera.
So it in the weekly
Now though
markets
it is
also.
already completely banned. How they were playing this sapera dance, I don't know.
Our forefathers were also saperas, my lord.
Acha.
I have many.
But now
clear-
you stopped all these things
My lord,
because it is already
In
banned.
fact, these are the persons like them are the persons who used to sell the tiger skin bones in the weekly markets also. We have found that aspect also. So therefore, lordship may kindly fix it on 3rd. We'll place it whether further
My lord,
custody
my
will
lord,
be
for
required or
last
not.
occasion, my lord, your lordship decided to dispose of today, my lord. For
I
last.
am not such a thing disposed of it today. It was
My
fixed
lord,
apparently.
my lord, kindly peruse paragraph 2 of my.
No, I don't have much time. If you want to insist only on this length of detention today, how many days?
34 days, my lord.
34 days is not sufficient. I think we are
Punishment
still searching.
Punishment is 3 to 7 years.
No, now Mr. Bora don't have, and he doesn't have anything before him.
My lord,
Whether is it, what is the stage of investigation, whether?
I think, my lord, nothing is required, my lord. Everything is in this offense report, my lord.
Where is the offense report?
Page 8, my lord.
Oh, that is the
That
offense.
is, my
Acha, acha.
My lord,
Third,
my
we are
lord,
fixing that.
Lordship may kindly fix it on
my
3rd.
lord,
By that
perhaps
time,
further custodial interrogation is not.
Yes,
required,
what to say, further custodial interrogation regarding?
My lord, all the snacks have been recovered from our possession, my lord. That is admitted fact, my lord.
Yes, your
there
submission.
is nothing with me, so I cannot just say right now
Yes.
that whether further custody detention is required or not.
Offense report is here, my lord. Seizure
This is preliminary offense.
Preliminary offense
also,
report.
Yes.
seizure list also here with this petition, my lord.
No, we are not on disputing it. He is also not disputing regarding this seizure. It's okay. You have also admitted that the recovery of those snakes from your possession is admitted fact. It's not disputed one.
Yes, my lord.
Now the question is whether further custodial interrogation is required or not. That is the only question. Preliminary report was there.
Yes, Saperas, my lord.
Only 10 more days, Lordship, because
all the snacks have been recovered
because if
from
your
our
lordship
possession.
fixes it around 3rd, yes.
Third or
Only 10 more days.
list on third.
Kindly consider detention period, my lord.
List on third. You're calling for this report, offense
Yes,
report.
we'll place the
Offense
instruction
report
on the range
for the else offense report and CD not yet received. The learned counsel, Mr. Bora, who is appearing for the special PP wildlife, is hereby asked to take necessary steps to in procuring the CD along with the offense report. Please the matter accordingly on 3rd of third, we are fixing.
May please your lordship, my lord, it's a in between, my lord, NDPS case, my lord. My lord, contraband is heroin, my lord, 107.02 grams, my lord. My lord, page 14, the quantity has been given, my lord. Page 14, my lord, from below sixth line, my lord. From below sixth line, my lord.
Yes.
The total weight found to be 107.2 grams, my lord, without soap drop, my lord. And the petitioner, my lord, before your lordship, both are addicts, my lord. And they are behind the bars, my lord, as on date today, my lord, 46 days, my lord.
7 days.
47 days. Nothing more to submit, my lord. Only length of detention, my lord, that much in between. My lord.
We have received the case diary, my lord. It is pending for FSL, my lord. And there are two accused persons, my lord. Procedural Rahman and my lord one Nur Hussain, my lord. Initially, my lord, from the possession of Mofizur Rahman, 11.43 gram was recovered, my lord.
11.43.
From the possession of Mofizur Rahman. Then he was interrogated, my lord. Then he has named the Nur Hussain, my lord. And from his possession, my lord, 107.02 gram recovered. So, my lord, as far as the materials are concerned, there are materials, my lord, except the, my lord, the FSL report.
Length of detention. Edict, my lord, to be honest.
Yes, further custody is necessary.
My lord, today is 47 days, my lord. Another 13 days, my lord, left to complete the investigation. 13 days, my lord. 13.
It will be in the
FSL is not yet received.
FSL not received. Today morning we have confirmed, my lord, FSL not received.
Heard Mr. N.J. Datta, the learned counsel for the petitioner, and also heard Mr. R.J. Borwa, the learned additional PP for so and so. This is an application on the section so and so. Did he received? Where is received? Hard both side. Mr. Datta, the learned counsel for the petitioner, submitted that these two accused petitioners are innocent. However, it is a fact that they are the drug addict, and some quantity of the heroin may be recovered. No. Is recovery you admit?
Yes.
Recovered may be informed their person, but they are not the drug peddler or is not involved in any kind of business. Further, Mr. Datta submitted that the accused petitioners are behind the bar. This stands 47 days, and hence, considering their period of detention, they may be under on bail. Both the accused petitioners are permanent resident of their address locality, and they will provide sufficient surety if they are provided with bail. Next para, Mr. Borwa, the learned addition PP submitted in this regard that there are sufficient materials available in the case record. A case diary. Initially, the petitioner number 1 was apprehended, and from his position, 11.43 gram of the contraband was recovered, and thereafter, from the petitioner number 2, 107.02 gram of contraband was recovered during the investigation. However, Mr. Borwa has submitted that the FSL is not yet collected, and investigation is still under process. Next, considering the entire submission made by the learned counsel for both sides, without going much about the merit of the case, only considering the length of detention, I just found that the IO got sufficient time for their custodial interrogation, and hence further custodial interrogation may not be necessary for the interest of the investigation. And where it is pending?
Special just come group matter.
Special just come group.
Okay. I'm obliging. Deeply.
48.
That is the lordship 58. Yes, 48.
Yes, in this case, my lord, I was arrested on 24/9/22 and forwarded to judicial custody on 25/09/22, and since then I'm custody, my lord, which states at my lord 2 years, 2 months, 25 days, 817 days, my lord, as on today. But I have prepared a small note regarding progress of the cases along with all the up-to-date order sheets and the PWs, my lord. These are the certified copies, man. I have furnished a copy to them also.
How many PWs examined till date?
My lord, only 2 witnesses examined. In this case, my lord, serial number 4 charges were framed on 21/6/2023, and thereafter, my lord, the learned trial court fixed 14 dates, my lord, issuing summons to the prosecution witnesses, but they did not appear, my lord. And lastly, my lord, on 19/8/2024, at serial number 20, my lord, one PW witness was examined, and thereafter, my lord, on 26/9/2024, another PW2, he was examined, and thereafter, my lord, then again, my lord, it is, they did not appear, my lord, and now the matter is fixed, my lord. Last it was posted on 4/12/2024, thereafter fixed on 31/2025 for further evidence, my lord. So, my lord, my humble submission is, my lord, considering the prolonged incarceration, my lord, and he is a local resident, my lord.
How many witnesses are there altogether?
There are 10 number
10.
10 number of witnesses, my lord. 10 number of witnesses are there, my lord. So my respectful submission is, my lord, from the progress, it is very much seen that there's very big chance of completion of trial at an early date, my lord. So if my lords may kindly consider his conditional liberty, any stringent condition, my lord. And further, my lord, I am a local resident, residing within the local limits of the special judge Karimganj. So I will abide by, my lord, any condition, my lord. In custody, my lord, since it is, my lord, 17 days on today. Depend on complete compilation also from Lordship's perusal. No.
Yes.
My lord, it's a commercial concept contraband, my lord. 504 gram heroin recovered from the possession of the petitioner, my lord. Now, my lord, search sheet was submitted on 15/3/2023, my lord. The dates are important, my lord. Search sheet submitted 15/3/2023. Thereafter, my lord, procedure furnished, my lord, and on 21/6/2023, my lord, charges framed, my lord. Thereafter, my lord, the first PW examined on 19/8/2024, my lord.
Yes.
19/8/2024, my lord, and between that period, my lord, PW they were not present, my lord. That is why could not be examined. And PW2 examined on 26/9/2024, my lord.
That is on very next day.
My lord, yes. And my lord, the PW2, my lord, Nurul Islam, my lord, he is a Caesar witness, my lord. He has implicated, my lord. Implicated the present petitioner. This is my humble suggestion. My lord, he is submitting on the basis of, my lord, long incarceration, my lord. So long incarceration, my lord, yes, my lord. On from 21/6/2023, my lord, there is a little gap, my lord. But my lord, from the order sheet, my lord, that my learned friends furnished to me, my lord. Someone was regularly issued, my lord. It is not that, my lord.
Every individual was taken.
Yes, my lord. Someone, it is not that someone was not issued, my lord. That is why PW not come. It is not that, my lord. Someone was regularly issued, my lord. But probably it was not served, my lord.
PW is not turned up, my lord.
Turned up.
Someone in most of the cases, my lord, someone returned unserved, or someone not issued, my lord. I have the order sheet is there. I have made the brief note also, my lord. Either someone not returned, or even though someone returned, my lord, PW did not turned up in this day. From 5/7/2023 till, my lord, 23/7/2004, there was no examination of witnesses. 14 dates, my lord, altogether. And thereafter, my lord, again also in 6/11, PWs are absent, my lord. 6/11/24, my lord. Then 4/12/2024, my lord, then also PWs are absent. And my lord, on 30, now it is fixed on 31/2025, my lord. And only, my lord, in this span, my lord, of 2 years, 2 months, only 2 witnesses could have been examined, my lord. So this weighs the, my lord, favor of, this lies in favor of, my lord, the petitioner, my lord.
Long incarceration, my lord, question will come, my lord, after framing of charge, my lord, when the trial will start, my lord. He cannot counter the, my lord, when he was behind the bar during investigation period, my lord. 180 days period, my lord, he cannot, by humble submission, my lord, he cannot count, my lord, as a long incarceration, my lord. He may only submit, my lord, after framing of charge, my lord. If there is a, my lord, insufficient delay, my lord.
My lord,
Then only, my lord, he can submit on the long incarceration.
Lordship, may I submit, Lordship? May I submit, Lordship? But my other senior has said that 180 days period has been has to be excluded. Now, in my lord, although trial has not been defined in CRPC and BNSS. Now, if we take the, my lord, interpretation which has been forwarded in Satyendra Kumar until case, I'll place this judgment, my lord. There, the Honorable Supreme Court has stated that for the purpose of bail, my lord, this period also to be calculated into, it has to be taken into consideration. I have read, my lord, I have the judgment along with me. If Lordship require, I'll place it, my lord. In Satyendra Kumar, until it is clearly stated, madam, that for the purpose of bail, the period undergone during the investigation, trial, and inquiry, that has to be taken into consideration, madam. And Lordship, if I may, with your permission, place this compilation, madam, where Lordship has also considered a similar occasion, madam. Madam, these are the Ravi Prakash Lordship has known, my lord, that delay, undue delay always, my lord, subside the rigors of section 37. Now, my lord, I'll request your Lordship to page 15, my lord, where Lordship was pleased to consider, my lord, bail application of one of the petitioner, my lord, who was also undergoing custody for 4th paragraph, my lord. Page 16 is the relevant.
Yes.
Yes, may I just read, my lord? Mr. Dotto, Lion Senior Counsel for the petitioner, submit that he is not insisting on the issue of compliance and non-compliance of section 42 NDPS, but seeking bail solely on the ground of prolonged incarceration. He submits that the petitioner has been in custody for the last 2 years, 14 days. During this period, prosecution has examined only 3 out of 10 witnesses. So, my lord, these was the facts, my lord, in this case, and thereafter, my lord was pleased to release the petitioner, my lord, with some stringent conditions, my lord. Page 19, paragraph 13 is the Lordship's order, my lord, whereby Lordship was pleased to grant him bail, my lord, considering the prolonged incarceration. I'm also a similarly situated person. And furthermore, madam, resident of the Karimganj itself, my lord. So there is no chance of absconding or not facing the trial. And I'll abide by any condition if my lords consider my application, my lord, at this stage, my lord. Okay. I'm deeply obliged. Madam, 49, there, my lord, one PW was excellent, but I could not obtain the certified copy. And the records that I
49
have,
also we have received this scan copy.
yes, records are also not up to date, perhaps, my lord, I have seen.
Record is not up to date, my lord. As per the last order dated 12/7/2024, my lord. The case was posted on 23/7/2024. After that, there is no update.
And
one PW examined, my lord.
exactly, yes, ma'am.
That is examined on 21/2, my lord.
21?
21/2/2020.
This time your petitioner is behind the bars?
Yes, yeah, he is only, my lord, 1 year, 3 months, 28 days. And my lord, I could not obtain the certified copies, although I have applied, my lord. Only thing that from the kiosk I have found that it is fixed on 17/1/2025 for recording of evidence, ma'am.
17 months.
Yes, 17/1.
So we can call for the scan copy of the after this.
I'll also
After the
obtain, my
scan
lord.
copy is record the call for the present status report in regards to number of witnesses examined by the trial court below, if any. If 17 is fixed, then let
After
it be
BU vacation.
after BU vacation.
23 or 24, my lord, if possible.
23 or 24 by 1. She is also This is a good time now.
Then
In
let,
all the.
let it be for 28, my lord.
Huh?
28,
28.
28, my lord.
28 one.
I'm
Or
deep-
for the updated scan copy of the case check.
I'm deeply obliged, my lord.
36.
36. Equal by equal, I'm going to say 36 gives to Amy.
May it please the lawsuit, my lord, the petitioner is enrollment plus 74 plus my lord. The other day, my lord, the fair copy of the FIR may kindly be read, my lord. The copy annexed.
The last occasion, amicus was directed to appoint an amicus, my lord.
Oh, is there any amicus now? No. Amicus happened one I need.
Section. Which section?
Oh.
Was sent to the section. Otherwise, officer should.
Oh.
We sent to the section.
Oh, who submitted this one? You?
I am for this paper I have given, my
Achha.
fair copy. My. There is no ingredients as such available of the section 7, my lord. Of course, the FIR has been filed under section 8. Section 8 is a provision for punishment. And if you read the section 7, my lord, you will also can see.
He submitted that most probably it doesn't reach to the section, in fact, for appointment. Otherwise, there could have been an appointment.
We can call an amicus, my lord.
Directly now.
My lord, if there is urgency, my lord, then you have to take it tomorrow, otherwise after vacation, my lord.
You can directly McLean find one.
Please see, in can be suggested. You can suggest.
In the cold days, my lord, he is about 80 years old.
Should be.
Tomorrow can be. Okay. It will work. It will work.
Record to section 4 direct bench of exceptional moment of the amicus control.
Tomorrow we'll take it. For my devotion, the Bible will go.
The board was suggesting NK Brown, she gives a very good submission.
MK Brown can be appointed. Then it will be listed on 3rd or 6th. We don't have any time. That's it. Oh, it is a AB.
AB.
Oh, then what is the urgency? It's a AB only. He's a very old person. He will not be arrested by police.
If that is provided by your office, madam,
No,
the interim.
interim cannot be.
Without hearing, my lord, interim cannot. After hearing the
Should not
amicus,
be.
my lord. There are implications, but 164 CS, the victim is implicated. It is not aggravated, but the touching part is there.
I had a writing. Heard Mr. M.H. Rajbognia, the learned counsel for the petition. Also heard Mr. R.J. Burga, the learned additional PB so and so. It is seen that that the registry has not appointed any amicus curiae to represent the respondent number 2, though the order was passed on 13/12/2024. Accordingly, I find it necessary to appoint an amicus curiae to represent the respondent number 2, full stop. And let MK Brown. No? Let MK Brown be appointed as an amicus to represent the respondent number 2. Otherwise, you have received the CD, no? Case diary is received. Retain the case diary to the list of listing. List accordingly on 6 or 7 QR code 7th of January. 7th.
57.
In this well-reflection lordships, page 9 is the affair lordships. This one is that feature lordships. May read the affair lordships.
page 9, type copy lordships.
Yes. So it's a very, I mean,
Long affair
bad
lordship.
allegation also. Allegations are also very bad, na?
No lordship, that is not true lordship. Actually, my lord, FIR, as per allegation lordship, incident took place on 6th of October lordships. And after FIR loss after several days, that is, my lord, 28
Incident of 6th of October.
lordships. As per allegations, 6th of October. And FIR loss, my lord, after several days lordships. That is 2810 lordships. And the informant is the friend of the petitioner's daughter lordships.
The informant is the friend
of the petitioner's daughter lordships.
Petitioner is aged about
50 lordships. He is 53 years old.
53 years.
Lordships. And he's a school teacher lordships. Kindly have I looked at lordship page 10, that is the my lord. The third paragraph lordships. But now they have been mentally harassing me in every way possible. Only because of that she has lost the affair lordships. My lord, if it is true lordship, she could have filed the affair in the instantly lordship. She has waited several days lordship, thereafter she lost the affair. So my lord, my humble prayer is that my lord, I will appear before an investigation officer, I will cooperate in investigation lordship. He's a school teacher lordships. So my lord, it is bail may be considered lordships. No specific allegation also dear lordships. Only that allegation. Otherwise, she could not have filed the affair lordships. If he says, if my lord petitioner petitioner my lord sexually harassed the informal lordships, she could have filed the affair instantly, and petitioner may not be lordship harass the petitioner and petitioner's family lordship may not harass the informal lordships in the every possible way what she has stated in the affair lordships. So my lord, my humble prayer is that she is a school teacher. So my lord, bail may be considered. I will appear. I will cooperate in the investigation lordships.
This is a very unfortunate incident, my lord. The victim is my lord, the accused daughter's friend, my lord.
Yes.
And my lord, as far as the materials are concerned, my lord, he tried to commit the offense, my lord. But there are allegations of molestation also, my lord. He tried to, my lord, remove her clothes, my lord, and puts her in the bed. These are allegations, my lord. He is aged about 24 years.
Well, may I submit the actual fact of the case lordships? Actually, my lord, petitioner's son had a love affairs with the informal lordships. And this petitioner standing between them lordships. He never
accused effect.
My lord, I leave it to this honorable court.
In that case, we have to appoint otherwise. How can it be? The petition is pending since last since when it is pending?
September.
September then. Obviously, for a considerable period it is pending, in fact. Pardon?
Interim protection, my lord. But POX is lack POX, my lord, 15 POX. Section 15, my lord.
15 POX.
My lord.
No, interim we are not going. Let the amicus be appointed.
Amicus be appointed, then my lord.
My lord.
Yeah,
We can appoint directly. Otherwise, it again reaches the court. Heard Mr. Mr. M. Hawk, the learned counsel for the petition. It is submitted by Mr. Borwa, the learned additional PP, that he made a contact with the OC of the jurisdiction police station, but it is intimated that the notice is received by the police station, but as the petitioner, as the victim of the informant, respondent number 2 resides in a very remote village, the notice could not be served yet. Could not be served yet. Full stop. Full stop. Next paragraph. From the record, it reveals that the case is pending before this court since 20/09/2024, and considering this aspect of the case, I find it necessary to appoint an amicus curiae to represent the respondent number 2. Accordingly, MS name But Mr. N.K. Kalita, as a legal, as a amicus security to representative, respond number 2. Here we received any case diary also? Case diary is already received, retained the case diary till next set of listing. List accordingly on.
Short date, my lord.
Huh?
Short date, my lord.
Huh?
Short date, my lord.
Short date?
After vacation, my lord.
Ah. Big former boss. I'm also tired. We don't have any days space. We're also tired because they say this. Night. Okay, night. Actually, you people, you are all are insisting for date. We don't have any dates. That is